a writ petition for hearing, my lord. My lord, the matter is a very short question of law that has already been decided by the Honorable Supreme Court. That question involved here is decided by the
Give your slip.
judgment. Kindly
See
listen, madam.
Give your slip. In time. In time.
One can file.
May I be permitted to mention, my lord, this is a matter of waiting for the final hearing. It is amicably settled as per the order of the Honorable Court.
Amicably settled.
Yes.
So withdraw it.
No, actually, it was settled as per the order of the court. It was against the police, my lord. And I myself is the petitioner of this case.
You're
My
the
lord,
petitioner yourself. Now, how are you wearing a band? How are you wearing all your gown and everything if you're a petitioner?
Sorry, my lord. Actually, I'm practicing here also.
So you don't know the conduct rules?
Sorry.
May I be permitted to mention?
Yes.
Lordship, I filed a writ petition involving violation of my legal right to solemnly affirm for the evidence. So this is a very urgent matter.
Give your slip. We'll see that, sir. Give your slip.
My lord, may I be permitted to mention one matter? But this is in regards of a writ petition. It was filed in the last circuit and due to
Give your slip. Give your slip.
Lordship, may I be permitted to mention one extension of
Who's here? Your junior.
My lord, my clerk is over there, my lord.
The clerk will address the court now.
My lord,
Mr. Sarkar, what is wrong with you? Yes, madam.
extension of interim order, your lordship. Another one, there was a direction upon the state respondent to file the opposition on last.
Give your slip. We'll see that, madam. Give this.
It's a alternative.
Lease, item number 1.
I
Yes.
beg to appear for the state.
Yes, boss.
That's why have served upon the private opposite parties, but the item has been dispatched but not delivered success. As per the current tracking.
Yes. What is the issue? You are the main, you are the answering.
Lordship. Lordship, actually, I want to
It has not
move
been
this
served
matter
upon
in
the
presence
other.
of the private respondent, Lordship.
Not served yet. Sir, but it has been item has been dispatched.
Let it be served, madam.
Lordship, I have a solution because this is a serious issue, Lordship. We can serve through the PS because he is from the private respondent is from the Rajganj police station jurisdiction.
Okay.
Because this is a serious issue and it should be disposed of immediately, Lordship.
You consider, why don't you consider its representation and decide it?
No, Lordship, actually, there is some rituals regarding the exhumation of the grave of the Muslim Muslim people, Lordship, and it is also in the Supreme Court cases also it is also decided that it should be dead body should be
So you can
exhumed
ask them to
in-
do all that. They have already approached you.
yes, Lordship.
You can ask them to do all that.
Lordship, then if the writ petitioner will do we will give all the assistance, Lordship. We will just we should maintain the peace and tranquility should be maintained. That we will be looked after. That we can be.
DM can always ensure
Yes, that we can be ensured, Lordship.
whatever rituals need to be followed, you can follow that.
Because it should be Islamic way. That is the main issue.
Obviously.
Yeah.
However, 6th April must be considered.
They are seeking for the police to exhume the dead body. How police will do that, Lordship?
Whatever it is, why don't you consider the representation?
Lordship, then there will be a direction. Petitioner will be exhumed the dead body in the presence of the private respondent, and police will give all the assistance. If any law enforcement will be
It is
that we can do.
it is only
কারণ এটা ইসলামিক
This-
হবে ঝামেলা লেগে যাবে
Suppose this is only about deciding the representation. You can put the conditions in the representation, let them challenge it.
Lordship, that we can.
Let them challenge that representation. If they are aggrieved by your directions or whatever conditions you are fixing for exhuming the body, let them challenge it.
If Lordship court will direct, that will be easier for us because at the time of the
Madam, this court can't do the work of the
Lordship,
district
when the
magistrate.
incident-
Please, madam, this court is not sitting to to do the work of a district magistrate.
Lordship, I
Yes.
understand, Lordship, but
You
the sit-
decide the representation whichever way you have to decide it.
ওই সময় ঝামেলাটা এসেছিল তার এক সমস্যা হলো ওই প্রাইভেট
The petitioner has preferred the present petition being agreed by the inaction of the respondent authorities in not considering or deciding the representation dated 6/4/2025, full stop. The case of the petitioner is that his son, Muhammad Imran, was lawfully married to one Miss Sahina Begum on 24/11/2022 in accordance with Muslim Shariat law. Full stop. A male child was born out of the said wedlock and is currently 6 months old. Full stop. Due to matrimonial discord with her husband, Miss MS Sahina Begum allegedly consumed poison on 13/11/2024 and was immediately admitted to the hospital. To a hospital, full stop. After undergoing treatment, she was discharged on 31/11/2024. Full stop. Subsequently, she was taken to her parental home, where her health condition deteriorated, and she unfortunately passed away on 8/12/2024. Full stop. After her demise, the parents of the deceased, allegedly with the assistance of others, forcibly buried the body of the deceased on the premises owned by the petitioner. Full stop. This act was carried out despite objections raised by the local residents. Objection raised by the petitioner as well as the local residents. Full stop.
The petitioner at that time was not present, sir. They are absconding.
It was buried in the father's
father of the
there.
deceased, Lordship.
Forcibly buried deceased on the premises owned by the father of the deceased. Owned by the, not petitioner, owned by the father of the deceased.
And their family members.
Not a premises of the petitioner.
It is premise of the petitioner.
Yes, Lordship.
All right. It's your premise only.
Yes.
Yes.
All right, on the premise of the petitioner only, take. Despite objection raised by the petitioner and the local residents, full stop. Then what did he do?
Well, we want to
Exhume the dead body.
do everybody and the.
All right. A mass petition dated 12/12/2024 was submitted by the residents to the SDM, Subdivisional Magistrate, Jalpaiguri, the Block Development Officer, Rajganj, and the Inspector in charge of Rajganj Police Station, requesting that the burial be removed from the said location and the deceased be laid to rest in accordance with the personal law at a designated cemetery. In accordance with customary religious rites
And Lordship, there
and in a
there is
designated cemetery. Full stop.
agreement between this father of the petitioner and there is a agreement between the father of the deceased and the lead petitioner that the father of the deceased will exhume the dead body, but till date he did not do so.
All right. However, no action has been taken by the
Right,
authorities
yes,
in
yes.
this regard. Full stop. In the meantime,
Well,
police complaint was lodged by the mother of the deceased against the petitioner and his family members, including his son, resulting in registration of FIR number. What is the name? FIR number 425 of 2024.
425 of 2020.
2024, dated 9/12/2024 under section 85, 80 and 103 of BNS. Full stop. The petitioner and other family members were granted anticipatory bail. Full stop. The
Has been granted bail by-
petitioner's son was initially taken into custody. and subsequently released on bail. Learned counsel for the petitioner submits that improper burial of the deceased without adherence to the religious rites and forcible use of petitioner's premise for such burial has caused severe mental anguish to the petitioner and his family. Consequently, the petitioner submitted a representation dated 6/4/2025 before the appropriate authorities, seeking exhumation of the body and reburial at the appropriate burial ground in accordance with the prescribed customary religious rites. Full stop. However, no decision has been taken on the said representation till date. Full stop. The petitioner has filed the present writ petition. Full stop. Learned counsel appearing for the respondent submits that there was an understanding between the petitioner as well as the father of the deceased, wherein the father of the deceased was supposed to carry out the exhumation of the body. Full stop. Though till date, no action has been taken. Full stop. Learned counsel for the respondent submits that they are ready and willing to decide the representation dated 6/4/2025 within representation dated so and so. Learned counsel for the petitioner states that he shall be satisfied if the same is decided within a time-bound manner. Full stop. In view of the statement made by the counsel for the parties, this court directs the respondent number.
Worship, respondent number. 4 and 5. The police direction is 3.
Which respondent will decide the representation?
Worship, let IC will decide.
IC will be too low to decide. Let the superintendent of police,
Worship.
respondent number 4, decide the representation dated 6/4/2025 within a period of 2 weeks.
In presence of both the parties.
Yes,
Worship.
within a period of 2 weeks from the date of communication of this order, after affording an opportunity of person hearing to the petitioner as well as the private respondent
Worship.
or any other stakeholders by way of a speaking order. With the present direction, the present writ petition is disposed of.
Worship. Grateful. Worship. 2 weeks এর মধ্যে হবে 2 সপ্তাহের মধ্যে
You please issue communication to both the father also.
Grateful. Worship.
बस वही रहने दो, वो लाइन हटा.
Mother, this is that matter where specific provision for appeal is available, mother. Under the Land Reforms Act, mother.
Where's the petitioner?
They are
Who's appearing, Mr. Paul? Last time somebody appeared, huh?
yes, mother. Neeraj Gupta. The last occasion they prayed for time, mother. Last
Will
week,
Pass it.
several occasions. Mother,
Pass it.
Item number 3 and 4 is not possible.
Why? What happened?
He's facing, I'm led by Mr. Abhimanyu Banerjee, he's facing some problem.
The care application has been filed. Has incident.
3 and 4 are connected? No.
Please, I don't see.
All right. So he's talking about 3. 3 you want to pass over? Pass over.
Five.
I am appearing for the respondent number My lord, I am appearing for the Siliguri Jalpaiguri Development Authority. My lord, I have not received any copy. Perhaps no copy has been served, my lord.
My lord, we have a affidavit of service out there, and my Miss Basu will hand over the affidavit of service to your lordship, my lord. My lord, before that, we have served through email, my lord. After filing of this writ petition, my structure was demolished. I have all the documents pertaining to my possession, my right, title, interest, and also certificate for this trade, my lord. But still, there
All
is
right,
no
send
process.
your, Mr. Mukherjee, send your email ID. You serve a copy,
lord.
have it day after tomorrow.
My lord, I'm grateful, my lord, extremely grateful.
And seek instruction.
My lord,
It seems
certainly.
like your action is not in accordance with law.
My lord, I shall take instruction, my.
As your lordship pleases, my lord. Much obliged.
Your Lordship, I'm appearing for item number 6. My learned friend may produce you the copies of the judgment of Patna High Court delivered by Justice Chandran, as well as a copy of the judgment of the High Court of Madras.
Yes.
আমাকে একটু দিস ওই কি কপি দিবি ওটা কালকে ওটার
As your lordship may see that on the yesterday lordship, we referred to the judgment of Justice Chandran, division bench judgment of Justice Chandran at Patna High Court. Similar case lordship, similar order has been passed.
and kindly give me that
They had come against the time barred lordship order, which was passed after 7 days, because lordship the legislature has fixed 7 days of passing the order lordship, and beyond that the order is non-est in law, void ab initio. So lordship, it is also without jurisdiction. So lordship, the Patna High Court, the division bench of the Patna High Court has also set aside the order. Lordship may kindly see the order of Pawan Caring Corporation versus Commissioner CGST. It has lordship specifically will help. Lordship.
Yes.
Lordship, even the
Yes, madam. Yes, madam, tell me.
Lordship, the Patna, as I said yesterday, Lordship, there were Patna High Court judgments, Madras High Court judgments, Orissa High Court judgments on the same issue, Lordship, on 129(3). Lordship, the order has to be passed within 7 days of the notice. Otherwise, it becomes non-est in law. Lordship, Justice Chandran from Patna High Court, Lordship, division bench judgment is there, Lordship. I have yesterday, Lordship, I relied on Orissa High Court judgment. Today, I am relying on Patna High Court judgment, Lordship, Pawan Caring Corporation versus Commissioner CGST.
Yes.
Lordship, in fact, the same case wherein section 129, the Lordship may kindly see the paragraph 3. Learned ASG, however, points out that the annexure C has given petitioner 7 days notice, which expires so and so, and then a period of 7 days has to be given for being heard as per so and so. The learned SG submits that habitually there seems to be mistake committing in the registration number. We notice that petitioner is similar in both the cases, but then the officer had to initiate proceeding and concluded within the time specifically provided under the statute. We are not convinced that the order can be saved on the grounds as stated by so and so, as we found in NSSR 6 provides for a notice within 7 days of detention and order within a further period of 7 days from the date of service of such notice. Subsection 4 can only speaks of an opportunity of being heard, which has to be necessary within 7 days period, and if the owner of the goods do not turn up. In the present case, we see that it is squarely covered by the declaration as stated in annexure so and so. We hence allow the petition, setting aside the order, Lordship, on the ground of limitation. Lordship, Patna High Court has given, Lordship. And Lordship, even Madras High Court, Lordship, if I may refer to the judgment of Madras High Court, Lordship, just by Justice Mohammed Safiq. Lordship, this is a very clear order. On the directly on the point, Madras High Court, Lordship, Madeshan versus State Tax Officer. Lordship, may kindly see paragraph 2 of the order. It is very, Lordship, that will make the things very clear. In this regard, the petitioner has relied on so and so. Lordship may kindly skip over and see the next page. In this regard, it may be relevant to note the following dates. Date of detention is so-and-so. Notice was issued on so-and-so. Order of detention is passed on so-and-so. It is submitted by both the counsel for the petitioner and respondent that the order under section 129(3) of the Act is passed on the 8th day from the date of service of notice. Whereas the time stipulated under section 129(3) of the Act is that the order ought to be passed within a period of 7 days from the date of service of such notice. In as much as admittedly the impugned proceedings are beyond the timelines stipulated under section 129(3) of the Act, the same is fatal to the order in terms of the order of this court in so-and-so. The impugned proceedings are set aside and the vehicle in question shall be released forthwith. Similar view has been expressed by this court in so-and-so. Following the above orders, this court is of the view that the impugned proceedings are liable to be set aside in as much as it is in contravention of timelines stipulated in section 129 of the Act. Consequently, vehicle so-and-so shall be released forthwith. Accordingly, this writ petition is disposed of. There shall be no order as to cost. This is the Lordship. Madras High Court order is there. Judgment is there. Odisha High Court Lordship. In fact, all the most of the High Court has given this type of orders. I have Lordship given the judgments of 3-4 High Courts. Lordship, on one issue, Lordship, as your Lordship, since in these cases, Lordship, directly against the order, they have gone to the Lordship.
Yes.
Mayor,
Yes, sir.
well, I dispute their facts.
See the merit of the case, not the time barring of the thing, which
All right, madam. All
refer
right.
to a judgment of Whirlpool Corporation, Lordship Supreme Court. On this issue, Lordship, Whirlpool Corporation versus
Kindly give me the
Register of Trademarks, Lordship.
Whirlpool Corporation. Trademark.
Lordship,
Paragraph.
paragraph 15 of the judgment. 15, Lordship. 15 is, Lordship, an encyclopedia in itself in respect of tax matters, Lordship. Paragraph 15. 15. Lordship, paragraph 15. Has your Lordship got it, Lordship? May I read, Lordship?
Pressing
Yes.
on alternative relate.
Lordship, under Article 226 of the Constitution, the High Court, having regard to the facts of the case, has a discretion to entertain or not to entertain a writ petition. But the High Court has imposed upon itself certain restrictions, one of which is that if an effective and efficacious remedy is available, the High Court will not normally exercise its jurisdiction. But the alternate remedy has been consistently held by the court not to operate as a bar in at least 3 contingencies. Number 1, namely when the writ petition has been filed for enforcement of any fundamental rights, or where there has been violation of principle.
Natural justice.
Justice.
All right, Ms. Sarkar.
My-
Yes, tell me.
As per the facts, my lord, the vehicle was intercepted
Or
24/2/25.
Yes.
Thereafter,
Page.
my lord. Page 55, my lord.
Yes.
And an MOV 01 for recording the statement of the driver was given, my lord. Thereafter comes the page 57, my lord. The statement of the driver was recorded, my lord. The 57, my lord, page.
Yes.
Thereafter, in page 59, MOV 02 was given, my lord, for inspection, physical inspection of the conveyance
Yes.
vehicle, my lord.
Lordship,
So,
this I'm so sorry, it got disconnected, Lordship.
Madam, let Ms. Sarkar submit. We'll have you later.
Yes.
Yes.
Okay.
Thereafter, the driver prayed for time, my lord, for 3 days.
Yes.
MOV 03 was issued, my lord, which they have not enclosed, my lord. I have those documents. the department person did not come yet, my lord. So they took twice time, my lord. On 26/2/25, so 3 days time was allowed because the driver said in front of the owner, kindly the inspection of the vehicle may be done. So on 26/2/25, 3 days time was given. Again on 1/3/25, another date time was given because the driver said that the owner did not come. So in front of owner, it may be done. But finally on 4/3/25, the physical verification of the vehicle was done, my lord. And on 6/3, the detention order was passed. That detention order also they did not enclose. So what does the law says, my lord? If your lordship sees 129(3), my lord. Says,
Just
my mind.
yes,
May I?
yes.
The proper officer detaining or seizing goods or conveyance shall issue a notice within 7 days of such detention. So it says, my lord, I pause over here, because the order of detention was passed on 6/3/25. So the show cause notice, or the notice referred herein, was passed on the very next day, that is 7/3/25, which they have enclosed, my lord, which is in page number 67. I think
Yes.
so. 67, yes.
67.
67. The show cause notice. Thereafter, what has happened, my lord? The show cause notice was handed over to the driver, my lord, as per the order.
Yes.
It speaks, my lord. MOV 09, but none appeared, my lord. And in the show cause notice, my lord, it has been specified a date, my lord, on 13/3/25.
Yes.
13/3, but none appeared, and hence on 19/3/25, a order was passed, my lord. Whether
So
it was,
this is after 7 days.
my lord, 1 minute, my lord.
Yes.
So what has happened thereafter, my lord? Thereafter, the owner of the goods appeared before the department, my lord, and he submitted that he did not have a knowledge of this show cause notice. So the provision of law says that, what does it says, my lord? It says that thereafter pass an order within a period of 7 days from the date of service.
Where are you reading?
My lord, 129(3).
Yes, proper officer detaining goods.
The proper officer detaining or seizing goods
Seizing
shall
goods.
issue a notice within 7 days of such detention. So since the detention order was passed on 6th, the notice was given on 7th.
Yes.
Thereafter, it says specifying the penalty payable, and thereafter, it continues, my lord. Thereafter, pass an order
Yes.
within a period of 7 days from the date of service of such notice. So the notice is required to be served. So when he comes forward to the department and says, I do not have the knowledge of the notice, my lord. So service was not affected, my lord. So the order was passed. Thereafter, my lord, if your lordship comes to page number, the order. Page 109, my lord, of their writ petition, my lord. Paragraph 8, their writ petition, my lord.
Paragraph 8.
8, my lord.
Yes.
Mm-hmm.
Yes.
8. It says on 24/4/24, Sri Baran Shaha, who is the owner of the vehicle, the goods, my lord, having Aadhaar card number such and such, came forward personally.
Wait a minute.
My lord.
Which page?
109 of their writ petition, my lord.
109.
My lord.
Yes.
My lord. Paragraph number 8, my lord.
Yes.
Yes. On 24/4/24, Sri Barun Shaha, having Aadhaar card number such and such, came forward personally and submitted a petition and claimed the ownership of the goods. He has also submitted that due to miscommunication with the driver of the vehicle, such and such, holding such and such, he could not turn up for compliance of the already issued show cause notice. The claimant of the goods was duly identified by Borun Shaha, was duly identified having registration number such and such. As the claimant want to pay the penalty of 129 of the GST, his prayer and submission is considered and new temporary GSTN number was issued, is allotted in favor of the claimant. A new enforcement case number was initiated accordingly. So, and thereafter he has also replied to the show cause notice, my lord. His reply is also annexed, my lord. Reply, page number 90. It shows date of show cause notice to be issued is on 24/4/25, 90. And thereafter it says page number 91. The petitioner acknowledged the receipt of your notice in 25th April 2025. Page number 91. They have given a reply to the show cause notice, and thereafter the order has been passed on 1/5/25. Within 7 days, my lord.
So you are taking the show cause notice from 24th.
My lord. They have come against that order, my lord. They are the petitioner of this case. They have replied to the show cause notice, my lord.
Madam, these are disputed question of fact. They are not admitting it. Sorry. Your conduct doesn't show that it has not been passed within 1 week.
Lordship, may kindly see, I'll just show only one document, Lordship, may kindly see page 105. What they are saying is not according to that, but they are relying on my document. Page 105. Page 105. The order which has they have passed, it has at point number 9, your Lordship may kindly see, date of service notice.
All right, not inclined to interfere.
And they have an alternative remedy, my lord.
Yes,
Date of service
they
of
will
notice.
go
They can
before
go for
the-
an appeal, my lord. That is my submission, my lord.
The petition, the present
Lord-
petition is
Lordship,
challenging.
I have only one more there, Lordship.
Madam,
Go to the appeal,
madam,
Lordship,
go
but my-
before the appellate authority. Madam, you go before the appellate authority.
Lordship, we will go to the.
You want
Okay,
findings
Lordship,
from me?
Lordship, please we'll go.
Madam, you want findings from me? I'll give findings. I will give
No,
findings.
Lordship,
It
I will
will,
go to the appellate authority.
madam, it will harm you.
Only-
You want findings? I'll give you findings. Or you go before
I am
the,
not asking for it, Lordship. I am sending, Lordship is sending to the appellate authority. Go to the appellate authority as your Lordship pleases. Only thing that Lordship may.
all right, withdraw it, go before the appellate authority.
Security.
Go before the appellate authority. Learned counsel for the petition to withdraw the presented petition to seek remedies before the appellate authorities in terms of section 107 of the WBGST Act.
I'm great.
Presented petition is
Grateful.
dismissed as withdrawn. 107. Act 2000.
এই দুটো দেখলেই তো হবে, এটা দেখালেই তো হবে। হ্যাঁ,
Lordship, may I appeal?
Yes.
Lordship, I am appealing on behalf of the petitioner. The last occasion direction was given upon the respondent
Yes.
to take the instruction.
Yes.
So we have sought for instructions, my lord. The matter is to be decided by the school service commission at this stage, my lord.
Who's appearing for the school service commission?
They usually appear from Not sure more.
Ms. Bomik,
For principal, page my lord, Mr. Sunitra. But he is not.
we'll pass it over. Call the concerned lawyer.
Lordship. Yes.
Pass over.
And I will go to respond on 4 and 5.
Yes.
The petitioner, my lord, is a registered industry under the medium, small and micro, just MSME industry.
Yes.
I had taken certain loan facilities from the respondent bank. The loan was sanctioned as a SME loan. Now, since 2008, my loan was going on. Subsequently, in around 2018, my lord, there was some difficulty in my business. Account became a little irregular. Notices were issued. Again, I made it regular. This continued. Then all of a sudden, my lord, action under the Surfacey Act was taken. Against one of the action, I had approached the learned Jalpaiguri tribunal, where I had challenged the order passed by the district magistrate under section 14. That was set aside. Now, today, my lord, I am before your lordship, being aggrieved by the action of the bank in not following the guidelines of the Reserve Bank of India in respect of MSME industries, where the guidelines have been formulated specifically for MSME industry, and in case there is a difficulty or a financial difficulty the industry is in, for rehabilitation and revival. That is the crux of that guidelines, my lord. Now,
So you're only agreed by the fact that the notification issued by the government has not been adhered.
has not been added. The notification, my lord, is starts at page 86, 88 onwards, my lord, is the notification. My lord is there at page 88.
Yes.
Now, I will, my lord, take your lordship to page 89. There's one very important point here. 2.1, my lord. In terms of gazette notification number such and such dated this, the enterprise has to be registered under as a under Udayam registration certificate online portal, my lord. This is a mandatory requirement for any MSME industry to have the benefits of this. Now, my lord, kindly comes to, I'll cover your lordship again, page 29, my lord. Annexure P1. My lord is there.
Yes.
This is my MSME registration. So therefore, my lord, this mandatory requirement on my part has been fulfilled. Kindly seize, my lord, this I could get the printout. Name of the enterprise is Shobita Enterprise. Sorry, automobiles, my lord. At column 11, date of commencement is 1st of January 2003. Now the column 14 says what is activity, what is my business, my lord. And at the top, my lord, it says Udyog Aadhaar Memorandum. There is a separate number, my lord, which is issued after this service. That this is important, my lord, was at a very belated stage acknowledged by the bank. Now I will, my lord, kindly takes up page 85.
Yes.
My lord is there. I will place it for a first paragraph. With reference to the above, we request you to advise us if your unit is classified as micro, small and medium enterprise as per the new criteria for classification the enterprise as micro, small and medium enterprises issued by the Government of India with a gazette notification SO 2119E dated 26th of June 2020, which my lord has been pleased to see at page 89, my lord. The gazette reference to that gazette notification. But surprisingly, my lord, in 2022, the bank says it is a new notification. This guidelines have come into force at 2017, and bank has started taking action dehorsed this guidelines from 2018. Now, it is my instruction, my lord, that this certificate was already with the bank. Now, I'll be candid, my lord, I do not have the receipt copy which the bank has acknowledged receipt. Now, my lord, kindly comes to page 91.
91.
91.
Yes.
My lord, is sure?
Yes.
Yes. My lord, will kindly come to 4.5. Debt restructuring mechanism for MSMEs.
Yes.
Banks are advised to follow the guidelines instructions on debt restructuring pertaining to MSMEs contained in the Master Circular, Prudential Norms on Income Recognition, Asset Classification, and provisions pertaining to advances as updated from time to time. All commercial banks are advised in terms of our circular such and such to do the following.
Yes.
Now, here, my lord, A, put in place loan policies governing extension of credit facilities, restructuring rehabilitation policy for revival of potentially viable CQ enterprises. Now read with guidelines on framework for revival of such and such. Then, my lord, continuation and non-discretionary one-time settlement scheme for recovery of non-performing loans for the MSME sectors with the approval of Board of Directors. Now, this was never done to me. On the contrary, my lord, if your lordship kindly comes to page 117. We had ourselves, my lord, approached the bank for an OTS. And this, my lord, I should not have shown this first, my lord, because it might create an impression that it has been rejected. Before that, my lord kindly comes to page 58-59. Now, collateral was given, admittedly, my lord, rightly or wrongly. I had written at page 58, my lord, which is in Bengal himself, my lord. I had requested the bank, and this was before even the scheme was advised to me. I had written to the bank requesting them that, see, my properties are there with you. You kindly give consent so that I can sell one of my properties and regularize my account or repay the outstanding loan. The reply to it, my lord, is at page 59. With reference to your letter, this is to inform you that we would be unable to release mortgage property with us with a partial payment of 35 lakhs.
Yes.
So, my lord, it was my effort, it has been my effort to settle the loan. Now, again, my lord, I will trouble your lordship with this scheme. Then, my lord comes to page 92. My lord is there. Page 92.
Yes.
It says, my lord, 4.6 framework for revival and rehabilitation of MSME. The Ministry of Micro, Small and Medium Enterprises, Government of India, via their Gazette notification dated such and such, has notified a framework for revival and rehabilitation of micro, small and medium enterprises to provide a simpler and faster mechanism to address the stress in the accounts of MSMEs and to facilitate promotion and development of MSMEs. After carrying out certain changes in the caption framework in consultation with the Government of India, Ministry of MSME, so as to make it compatible with the existing regulatory guidelines on income recognition, asset classification, and provisioning pertaining to advances issued by RBI. The guidelines on the caption framework, along with operating instructions, were issued by the bank on March 17, 2016. The revival and rehabilitation of MSMEs units having a loan up to 25 crores would be undertaken under this framework. My last my lord, loan was around 89 lakhs. So I fall within this one. Now comes to the salient features of the framework as under, just below that. Before a loan of account of an MSME turns into a non-performing asset, I'm at page 92.
Yes, yes.
banks or creditors should identify incipient stress in the account by creating 3 subcategories under the special mention account SMA category as given in the framework. Any MSME borrower may also voluntarily initiate proceedings under this framework. Committee approach to be adopted for deciding corrective plan actions. Timeline has been fixed for taking. None of this has happened. An NP has been declared by law. And that I will also come, my lord. 332 notices, 3 different dates of NP.
That is why auction notice has been issued.
Yes.
You have to be in.
Property has been auctioned also.
Then
Property has been auctioned.
Yes,
Property has already been auctioned.
already been auctioned.
one property has been auctioned.
They are against one property only.
And during pendency after the service, my lord, 2 other sale notices have come. Yesterday I received this. So I will pray for a leave to file a supplementary affidavit taking those into account.
What is left here? If the property has already been
My lord,
auctioned,
they challenging the 13-4 notice, they have preferred an essay, my lord, which has been dismissed for default, my lord, which they have suppressed. There is no reflection in the petition, my lord. And my lord, bank
maybe you're
proceeded
not
with the
aware, please
recovery.
say that. What is left here? If the property has already been auctioned, what is?
There are other properties also.
How
So
they
you
can
challenge
involve that
whatever.
under this, kindly see the petitioner.
What has happened, my lord? Now, this account was classified as NPA. And subsequently, all other accounts of mine were classified as NPA. Now, today here, my lord, I am before your lordship challenging the very classification of as an NPA. Vis-a-vis, my lord, the scheme.
Whether they have taken this point at the time of filing the essay or not, that has to be ascertained, my lord. Because the essay has already been dismissed for default, my lord. They have not proceeded. Thereafter, my lord, bank has filed application under the Recovery of Debts and Bankruptcy Act. In that matter also, the application has been disposed. They have not preferred any appeal there.
That I have disclosed, I have not suppressed that.
Yes.
They have not. They have remedies.
No, remedies are.
They have remedies. They have not resorted to the remedies. There are statutory remedies.
I am here because of the non-compliance of RBI guidelines by the bank.
Whether they can take this point at this juncture.
Not at this belated stage.
My lord, the bank has never come up with any explanation, my lord, why this mandatory provisions were not followed by the bank.
This is, you're only relying on the notification.
Yes, fine.
But this is the dismissal order. This has been suppressed.
Not suppressed, my lord.
Nobody mentioned.
Corrected.
Huh? Challenging 13-4 notice.
There's one, my lord, which I have said.
They have challenged the section 14 notice also. That was.
CRT order, my lord, certificate has been issued, that has been disclosed.
That was disposed as bank sought for liberty to file afresh.
My lord, one thing to be for lordship's kind consideration. Even my lord, supposing in other forums I have not taken up this point of this. Can the bank proceed, my lord, by not following a mandatory direction of the Reserve Bank of India? Especially, my lord, in respect of an MSME.
Well, they can take this point in appeal under section 20 of the Recovery of
So
Debts
here,
and
my lord,
Bankruptcy Act.
here, my lord, I am at very classification of NPA has been challenged.
All right, take down. The petitioner has filed the present writ petition challenging the entire process initiated by respondent bank under the provisions of Surfacey securitization and reconstruction of financial asset and enforcement of security interest bracket Surfacey Act 2002. Full stop. The challenge includes the alleged illegal possession and sale of petitioner's mortgaged property in connection with small and medium enterprise loan account. Full stop. Loan account. Small and medium enterprise loan account. Full stop. The case of the petitioner is that it is a registered MSME unit that had availed loan facilities from the respondent bank. Upon failure to repay the loan in a timely manner, the respondent bank initiated recovery proceedings under the Surfacey Act, full stop. The DRT, comma, Siliguri by Debt Recovery Tribunal, Siliguri DRT, by, which is the order?
Para 7, page 17, para 29. They have themselves admitted.
Suppress.
The DRT by order dated 28/6/2024 in OA number. This is. What is the OA number?
OA number 19 of 2022.
19 of 2020.
Under the recovery of debts and bankruptcy.
Disposed of the petition and permitted the respondent bank to recover the outstanding dues through auction of the secured assets. Full stop. Pursuant to this, comma, the respondent bank issued e-auction notice dated 7/1/2025. Full stop. Agree by the said proceeding and the steps taken by the bank under the Surfacey Act, the petitioner has approached this court. The petitioner states that the learned counsel petitioner contends that the proceedings initiated by the respondent bank under the Surfacey Act is in violation of the guidelines issued by the Government of India pertaining to MSMEs. Full stop. It is submitted that as per the guideline, comma, before classifying the account of a MSME as a non-performing asset, comma, the bank is received and the petitioner and the respondent and has perused the materials on record. Full stop. The materials on record reveal that the petitioner availed the MSME loan from the respondent bank. Full stop. Owing to the defaults in repayment, comma, the bank issued multiple communications to the petitioner inter alia dated 3/12/2018, comma, 19/7/2017 and 10/10/2019, informing the petitioner of the continuing default and that the assets would be classified as non-performing assets. Full stop. Subsequently, comma, the respondent bank issued notice under section 13(2) of the Surfacey Act on 28/10/2019. Full stop. The petitioner's account was declared non-performing on NPA on 13/6/2021. Full stop. Thereafter, Surfacey proceedings were initiated, comma, several notices were issued to the petitioner, including a possession notice. Full stop. The DRT Siliguri wide order dated 28/6/2024 in OA number 19 of 2022, comma, upheld the bank's actions. Full stop. The bank has proceeded with steps for e-auctioning of the secured assets. Full stop. Notably, comma, the petitioner, comma, despite being aware of the entire process, comma, failed to challenge any of the actions taken by the respondent bank at the relevant stages. Full stop. Although the petitioner claims to have MSME status, comma, no effort was made by the petitioner to apprise the bank of or the tribunal of this fact, nor was any objection raised regarding non-compliance of the MSME guidelines, full stop. The Honorable Supreme Court in Pronits versus Board of has categorically held that the compliance with MSME guidelines is mandatory. However, in paragraph 17 of the said judgment, the court has clarified. I'll give you the judgment. Full stop. Applying the said principle to the present case, it is evident that the petitioner had made ample opportunity to assert MSME, had ample opportunity to assert the MSME status during the Surfacey proceeding or before the DRT, full stop. However, it failed to take any steps to assert such a claim or object to the alleged procedural lapses at the relevant time and before the relevant authorities, full stop. The petitioner has now approached this court at a belated stage, when the proceedings have reached the final stage of e-auction, seeking to invalidate the entire recovery process, full stop. Such conduct cannot be countenanced in light of the law laid down by the Honorable Supreme Court, full stop. In view of the foregoing, this court finds no merit in the contention of the petitioner. The petitioner has slept over his right and has failed to take timely action, cannot now invoke its MSME status to stall the recovery proceedings. The Surfacey Act does not contemplate such an action. The presented petition is dismissed.
Grateful.
The Surfacey Act does not contain such interference at such a belated stage, especially when the borrower had sufficient opportunity to raise the plea before the appropriate authorities at an earlier stage, full stop. The presented petition is dismissed. Petitioner has stated that has fairly admitted that he has not informed the bank or has pleaded the MSME status at any of the stages. Yes. You said that there is no stamp that you have informed the bank that they have a. That's what I've recorded.
Yes, that I have said that I have nothing to show that.
That's what I'm recording, sir. Yes, tell me what.
My reading is that I have already.
Reading doesn't matter. You have to show evidence. Should I clarify that? Though the petitioner states that in the pleading he has stated that he has informed the bank of his MSME status, but he fairly concedes that he doesn't have any document to support such pleading, and the receival of the fact and has nothing on record to show that such information was communicated to the bank.
I can agitate those points before the.
Before, absolutely.
Before the tribunal.
Yes,
Not
before tribunal, before.
No, not there, but.
Yes.
That is clarified that I can take up those.
You always have the liberty. This liberty is always available to you. You should have actually tried it before the tribunal rather than coming here. At this stage, this will lead to stopping the entire proceedings.
That is a fundamental point of classification.
Classification at this stage, you should have taken classification at that stage, sir.
Banks would have also followed.
You have not done anything with the bank. Why didn't you follow up with the bank? You don't even have a letter showing that you have told them about your MSME status.
They have given me
That's all right.
Loan.
That's okay.
Sanction letter says it's an
That's
SME.
okay. But for availing that also, you have to show them that you have been certified under the Udyan scheme.
Yes. Certificate is.
That's correct. But the certificate has not been communicated to them, sir.
Yes, that I don't have a receipt. 2003, my lord, it is going on.
And you're coming here in 2025.
Non-compliance, my lord, I
At a-
don't think.
After so many years.
No, 2018 onwards, my lord, this started. 2008 onwards, my loan was there. It was fairly regular. Then my lord knows in business. my
Today
lord,
you have come here only to stall the entire process. You could have taken this defense at the time when the assets, when the time the account was being declared NPA. You could have taken all this ground.
No, my lord, what I.
Even
gathered-
before the DIT, you could have taken. Look at the order. Look at the order of DIT. You don't even appear before DIT.
What I've gathered, my lord.
I mean, this, I would have interfered. Look at this. Look at this. What sympathy do you expect from this court?
Gaurav, there is no reflection in the petition regarding this proceeding.
And that's all right. They know about it.
না এটা রিফ্লেক্ট তুমি 18-19 করেছো
Still, we try to settle. We have asked the bank for a release.
Still, look
They
at,
can release one of
now
their-
this conduct, does it warrant any kind of sympathy from the court?
Not one negative conduct
Sorry.
against my
No,
lord. the other step.
now look at the stages. If it was earlier, I would have interfered. Not at this stage.
Grateful.
Yes.
These court finds no merit in the confirmation of the petition. The petitioner must say over his right in the same.
Correct. Correct.
Now it invoke.
Comma, cannot now invoke
Now.
its MSME status to stall the recovery proceeding. The Surfacey Act, in view of the foregoing, comma, this what? In view of the foregoing. Foregoing. Yes. Affidavit of service taken under.
For the petitioner, item number 9, lordship. This is my affidavit of service.
Madam, for the response number 3 to 5. Madam, for the response number 3 to 5.
Yes. My lord,
Yes, Ms. Boss. Yes, what is that?
the petitioners are presently working as teachers in different government aided schools
Yes.
situated within the jurisdiction of the DI of schools, Siliguri.
What do you want?
My lord, A category pay scale in terms of the order of the Honorable Division Bench in FMA 804 of 2019 and also in MAT 107.
Yes. Ms. Boss, who's going to consider this?
My lord,
The
Chairman,
chairman, who's appearing for the chairman?
Madam, for the response of 3 to 5. But may I submit one thing?
Yes,
Earlier,
sir.
my learned friend filed a writ, my lord, filed a writ petition 2547 and under trial judge, single judge passed an order and we preferred an appeal as the order is not in though the learned trial judge directed the council to consider the case in the light of the decision taken by the Honorable Division Bench. But in addition to that, he also directed, learned trial judge directed to pay interest. Only for that portion, my lord, we preferred an appeal, my lord. As the appeal and the learned appeal court got that portion only. As such, my lord can direct the chairman of the council to consider the case in the light of the decision taken by the Honorable Division Bench, my lord. But my lord, one difficulty is arising. My learned friend annexed a document, annexure, my lord, 15, my lord. Kindly see annexure 15.
Yes.
Annexure 15.
Yes.
My lord, annexure 15.
There's no annexure 15, sir. The last annexure is annexure 13.
Yes, sorry, my lord, yes, 13. Page 51.
Yes.
Under a representation submitted before the council on 28 May 2024. My lord, there are 7 applicants petitioner in this writ petition, but earlier writ petition there are only 6 writ petition, my lord. Kindly see the earlier writ petition. My junior will supply you a copy, my lord. Last man, they manufactured this document. they inserted the name of last man, Amor Krishna Bala.
Yeah, what have you
In the
done?
original application, there's no
Given,
no such signature. And my learned friend also appeared in that matter, my lord. Whole difficulty is this.
What are you saying?
There are six ID hostile applications name.
I have no objection, but he has inserted the name of last man, Amor
only-
Krishna Bala. In the original application, his name was not there.
Subhajit Bose, right? This one is only three. Three are there.
Seven lordship at Amon Krishna Bala, as I have given by my client's lordship. At seven lordship, Amon Krishna Bala is there.
What? Seven.
Amor Krishna Bala is not the original application. Kindly see the earlier petition, my lord. Annexure P 11, my lord.
No, you please tell me. I can't understand what he's saying.
He is saying that maybe Amon Krishna Bala has not filed representation, but lordship, the representation that has handed over to me by my client, here it shows that Amon Krishna Bala is there.
Here, show me the representation here. What is on record? Annexure 13.
Yes, my lord. And my largest friend was there.
No, but it is here. Page 13.
Maybe
Seven is there.
it may happen that due to at the time of my lord taking photocopy, any name may have been not come in the.
Is there?
আচ্ছা তো।
I have to accept the
Anyway, you decide the representation. Whoever is here, you decide the petitioner agreed by the non-grant of A category scale of.
My lord, kindly see the earlier copy of the page 53, my lord.
Sir, you just consider the representation.
My lord, but yes, added one person, my lord. In the original application, the name was not there. My learned friend also filed a writ petition. In that little petition, his name was petition number 3 name was not there.
You decide the representation, Mr.
Yes,
Hal.
my lord,
He has not filed representation. His case will. Yes, sir.
But also kindly record the name of respondent number petition number 3 was not there initial.
Mr. Haldar, you decide the representation, all right?
Yes, my lord.
Certain law is there, Lord.
Unnecessary objections. No reason.
No, my lord, original application is name of the petition was not there, my lord.
Can I record my order?
Yes, my lord. My lord, pass the order, my lord. I have no objection.
Can you keep quiet? Then
Yes,
I'll
my
pass
lord.
it on. And ensure you don't speak in between.
No, lord. I am not. I will not disturb, my lord.
Thank you so much, Mr. Haldar.
My lord can pass the order.
Take down. क्या लिखा है तुम्हारा? By the non-grant of A category scale of pay with effect from the day when they completed the primary teachers training as per the judgment of the Honorable Division Bench of this court in MAT 107 of 2022, and also the decision of the coordinate bench of this court in WPA number 9201 of 2024. This is it?
Lordship.
Listen to this. What are you doing?
Yes, Lordship.
What did I say?
I was searching an order, Lordship.
Full stop. The petitioners are assistant teachers working in various schools under respondent number 3, full stop. They have completed their primary teachers training in July 2006, however, the exam was conducted in the year 2011 due to pendency of various litigations, full stop. All the petitioners have successfully cleared the said examination held on 14/7/2011, full stop. The school education department, bracket में, primary branch, Government of West Bengal, issued a notification dated 4/3/2013 permitting to treat the primary teachers who have obtained 1 to 2 years of elementary education from the state recognized institution and appointed on or before 31/12/2005 as trained teachers and to draw a category scale of pay. This is what it is? All right. It is the case of the petitioner that they are entitled to the benefit of the said notification dated 4/3/2013, full stop. This court has extended the said benefit to similarly situated teachers wide judgment dated 5/1/2024 in MAT 107 of 2022 and also the decision of the coordinate bench of this court in WPA number 9201 of 2024, full stop. The petitioner had submitted a representation dated 28/5/2024 requesting to extend the benefit of the said notification dated 4/3/2013 as extended, as extended to similarly situated teachers, full stop. However, till date, no action has been, no response has been received on the representation, full stop. Being aggrieved by the same, the petitioner has preferred the presented petition. Learned counsel for the Learned counsel for the respondent submits that they are the respondent number 4, right? 4 is the respondent number 4 submits. Learned counsel appearing for respondent number 3 to 4, 3, 4, and 5 submits that they are ready and willing to decide petitioner's representation dated 28/5/2024. Full stop. Learned counsel for the petitioner states that he shall be satisfied if the same is decided within a time-bound manner. Full stop. In view thereof, respondent number 4 is directed to consider and decide petitioner's representation dated 28/5/2024 within a period of
6 weeks, Lordship.
6 weeks. Now you're muted. I didn't say mute yourself. Yes. Yes, Mr.
Yes, my
Halwar.
lord.
How much time?
4 weeks, my lord.
Obliged,
4
Lordship.
weeks.
Within a period of 6 weeks. Within a period of 6 weeks from the date of communication of this order, after affording an opportunity of personal hearing to the petitioners, first by way of a speaking order, with the above direction, the presented petition is disposed of.
Obliged.
Grateful, my lord.
Time for the petitioner, perfect service has not been completed and paying for this.
Service not complete. Learned counsel petitioner states that service is not complete. Let this matter and prays for this matter to be listed before the next available circuit bench.
Lordship in item number 11, I am appearing on behalf of the appellant petitioner. Lordship, in this matter, the service has been completed, but the item has not been delivered to the other side. Would be very grateful if my lord kindly fix this matter before the next available circuit bench.
Service is complete.
Service has been completed, Lordship, but the item has not been delivered to the other side till
What
now.
has been not delivered to the other side? Where's the service report? Where's the service report? What is the issue?
Lordship, this matter is being led by learned senior counsel Sri Shankhu Shubhro Rai, who has
There is-
instructed me to take, because who has instructed me as because this service.
Show me the service report.
Lordship, it's not.
Next available circuit. At the request, learned counsel petitioner requests for this matter to be listed before the next available circuit bench. At the request of the learned counsel petitioner, list before the next available.
Where, no, I have the petition. All this so-called considered different is nothing. Yes, but considered no implementation.
Pass.
Having.
Okay, by item number 15, I beg to appear on behalf of the petitioner. This is my. The petitioner complains regarding the illegal construction being raised by the respondent number 9, private respondent number 9. Lordship. My representation is at page number 28, annexure P4.
Decide his representation, unauthorized construction. The petitioner is aggrieved. Unauthorized construction, just see if there's any unauthorized construction or not. This must be civil suit. They're neighbors.
Yes,
They're neighbors.
they allege that their easementary right has been violated. For that, they can appeal before the concerned city.
Lordship, that's a different issue totally, but.
You just
if there's
decide
an-
the unauthorized construction part, nothing. Where's the representation? Which page?
Lordship, at page number
38.
28. Page 28.
38 is your representation?
28, Lordship.
28. The petition is aggrieved by the inaction of the respondent in failing to take appropriate steps to prevent unauthorized construction being carried out at apartment number B11, Basundhara Abasan, Satellite Township, Dabgram, District, Jalpaiguri, alleged at the instance of the private respondents. Respondent or respondents? Respondent, full stop. The petitioner is the owner of apartment number B12, situated adjacent to the said premise, full stop. The private respondent, being the petitioner's immediate neighbor, is undertaking unauthorized construction at his premises, which is causing serious inconvenience to the petitioner, full stop.
That is apartment number B11.
B11,
B11. They are adjacent and they are sharing the common wall.
B11, B12,
Yes,
all right.
they are sharing
This-
the common wall.
Despite the petitioner having made multiple representations to the concerned authorities, no action has been taken by the respondent till date, full stop. Learned counsel appearing for the respondent submits that he is ready and willing to consider petitioner's representation dated 19/5/2025. Full stop. Learned counsel for the petitioner states that he shall be satisfied if the same is decided within a time-bound manner. Full stop. In view of the above, the presented petition, the presented petition is disposed of with a direction to the respondent to consider and decide petitioner's representation dated 19/5/2025 within a period of 8 weeks. Within a period of 8 weeks from the date of communication of this order, after affording opportunity of hearing to the petitioner as well as the private respondent by way of a speaking order. With the above direction, the present writ petition is disposed of.
The report filed by the city.
Report filed by, there's a report.
Yes.
Lordship, affidavit of service.
report filed by the
Respondent number 7.
respondent number 7 is taken on record. Tamam, ये report.
We can be taken into consider one specific case and your case.
All right, learned, उस पे एक ऊपर डाल देना. Learned counsel for the जहाँ willing, ready and willing है ना उससे पहले लिख देना. Learned counsel for the respondent states that there's a private dispute between the parties and the who has filed the case?
It is a specific non-FIR case.
Is a private dispute between the parties and litigations are pending inter se between the parties. That's right?
The non-FIR that has been filed against the private respondent.
Who has filed the non-FIR? He has filed.
It is the concerned SI of Jalpaiguri.
It's a private dispute between the parties, though he is ready and willing. I've just
Yes.
put one line and
Okay. Yes.
yeah, 5 minutes. I'll just come back in 5 minutes. I'll be back in 5 minutes. Yes.
Item number 40.
Not representation. Why didn't he file? Why didn't he decide the representation after so long he has been sitting over it? Yes,
The previous petition, I wish to apply your lordship to the fact.
yes. Give me the dates.
Yes, my lord.
Give me the date of application.
The date of the application is 9th November 2023.
9th November 2023.
Praying that that your lordship passes direction for the district magistrate to
All right.
consider the application. Take steps positively within 10 days.
Take down. Petitioner, comma, scheduled commercial bank, comma, has approached this court by filing writ petition, comma, being aggrieved by the inaction on the part of the respondent authority, comma, particularly the district magistrate, comma, Darjeeling, comma, in not disposing the application of the petitioner under section 14 of the Surfacey Act. Full stop. Learned counsel for the petitioner submits that the petitioner bank had initiated proceedings under Surfacey Act for recovery of its dues from a defaulting borrowers by proceeding against his secured assets. Full stop. Pursuant thereto, comma, an application under 14 of Surfacey Act was, section 14 of Surfacey Act was filed before the district magistrate, comma, Darjeeling, comma, on 9/11/2023, comma, seeking assistance for taking possession of the secured / mortgaged property in accordance with law.
My lord, one more request, if I may. My lord, if further clarifications are required by the state, then the same maybe communicate.
Is ready to decide your application. It is further submitted that section 14 of the Surfacey Act mandates the district magistrate or the chief metropolitan magistrate, comma, as the case may be, to take possession of the secured assets and documents related thereto, comma, and hand them over to the secured creditor, full stop. Although the provision stipulates no rigid time frame, comma, the statutory intent, comma, as interpreted by judicial pronouncements, comma, requires such application to be disposed of preferably within 30 days from the filing, full stop. However, comma, despite the lapse of more than 7 months from the date of filing of the said application, comma, no action has been taken by the district magistrate and, comma, and the application continues to remain pending without any justifiable reason or explanation, full stop. The petitioner is, comma, therefore, comma, constrained to approach this court seeking necessary directions, full stop. Learned counsel for the respondent, district magistrate, respondent number, learned counsel for the respondent one states that they are ready and willing to decide, the petitioner's representation, full stop. This court has heard the argument advanced by the learned counsel for the parties and has perused the materials on record. It is evident from the record that the application under section 14 of the Surfacey Act was filed on 9/11/2023 and is still pending adjudication, is still pending consideration before the district magistrate, Darjeeling, full stop. The prolonged inaction defeats the very purpose of Surfacey Act, which is enacted to ensure speedy recovery of dues by secured creditors through enforcement of security interest without intervention of courts and tribunals, full stop. The delay in processing such application undermines the efficacy of the remedy provided under section 14 of the Surfacey Act and adversely affects the rights of secured creditors, in particular scheduled commercial banks, which are statutorily empowered to enforce security interest in accordance with law. In view of the above, this court is of the opinion that the inaction on part of the district magistrate, Darjeeling, in disposing of the said application is wholly unjustified and cannot be sustained, full stop. Accordingly, the district magistrate, Darjeeling, is directed to take up and dispose of the petitioner's application dated 9/11/2023, filed under section 14 of the Surfacey Act on its own merit, in accordance with law, as expeditiously as possible, positively within a period of
8 weeks.
2 weeks. Within a period of 2 weeks from the date of communication of this order, it is made clear that court has not expressed any opinion on the merit of the application, and the same shall be decided independently by the concerned authority in accordance with law. With the above direction, the present writ petition is disposed of. You have already sat over it for 7 months. You want 4 weeks?
No. Lordship.
It should be done in 1 week.
Lordship.
Affidavit of service is taken on record.
I bow down.
This is a ministerial job. You don't even do that.
Grateful, Lordship.
Yes.
In the year 2022, was increased license vacancies in university. And for one vacancy.
FPS.
FPS license.
Yes.
One lady was, after verification by the respondent authority, one lady was, got that license. And, I being the second, rank, my, application is still rejected. Now, after some time, petitioner came to know that that lady has obtained the license with some all documents. And on that basis, he preferred an one writ application before this Honorable High Court. And after the final hearing of this, Honorable High Court, as per the order of the Honorable High Court, one further verification, physical verification, in presence of both the parties and BLRO SDO, as a. And on that basis, the license of that lady has been cancelled. Now, the last order of that subdivisional control was that has never considered the second rank candidate, which is the petitioner, and he tagged someone there nearby the appeals. So my evidence is that I am the second highest candidate, I should make.
Show the order,
Lordship.
earlier round of litigation.
Lordship.
Show the documents, please.
And still one.
And next.
13 with the license, the. Notice.
This is the notice of,
Notice of, it is vacancy.
all right, this is 22. All right. You participated,
Yes,
then
I have participated and I have been rejected as second.
where is that? Where is the letter?
The rejection order I have not annexed because Lordship last or judgment order I have annexed.
Yes, where is that?
Lordship page 60 and it's still P2.
Participated. All right, then the BLRO order, suspension.
Yes, next. Suspension on the Lordship, second, and simply four.
Is there a cancellation order also?
Yes.
Which page?
Not cancellation.
Only suspension.
Last year, Lordship, the jury was revoked and hereby suspended.
So you have revoked the license.
The license not revoked, which is a suspension in view of the order passed by.
But it has revoked and suspended.
It is already written there, revoked and suspended.
And so far that we are not, we are stating that we are the second best candidate.
So you consider her representation,
That can be done.
if she is found to be complying with all the formalities.
They are also annexed, he is not the second best candidate. Because there are 6 applicants out of which.
Lordship, in earlier petition, respondent authorities filing affidavit have stated that all the documents of the this private respondent was correct.
No,
After physical verification, presence of both the parties, it found that the documents are not open.
All right, what date is your representation? Which page?
Page
Number.
80, right?
80.
80. Where's the date in the representation?
30 January.
30th May. May or January?
30th January.
No, it was.
Where is the date?
30 January, date of the representation. Date is not available.
Your representation has no date, madam. Take down. The petitioner has preferred the present writ petition seeking a direction upon the respondents to issue the fair price shop bracket FPS dealership in his favor for Madhya Hudumdanga. This is Hudumdanga. -017. ये पेज 13 में मिल जाएगा. HUDUM Danga. Under Gram Panchayat Devanganj, PS Haldi Bari, District Pooch Bihar. Full stop. The case of the petitioner is that, in response to the vacancy issued wide memo number 263/SCF, ये यहाँ पे हाँ, ये लेगा page 13. SCF and S/MKG/22 dated 8/8/2022, he, along with other eligible candidates, had submitted applications for the said dealership. Full stop. Following the selection process, one Srimati Rahila Praveen was selected for the dealership. Full stop. Agreed by the said selection, the petitioner preferred WPA number 19117 of 2023, which was finally disposed of by judgment dated 14/11/2024. Full stop. Pursuant to the said judgment, the respondent conducted a field inspection and subsequently suspended and revoked the FPS dealership of Srimati Rahila Praveen on the ground of misrepresentation. Full stop. It is the submission of the petitioner that he satisfies all the eligibility criteria as per the original notification, and therefore, the FPS dealership ought to be granted in his favor. Full stop. He has filed representation in this regard, however, no response is yet received. Full stop. Learned counsel appearing for the respondent. You're appearing for the respondent. Respondent number?
Respondent number, my lord, all the stated.
Respondents.
All the respondents.
Submits that the authorities are willing to consider petitioner's representation and take appropriate action within a time-bound manner. Full stop. In view of the above, the presented petition is disposed of. Learned counsel for the petitioner states that he shall be satisfied if his representation is decided within a time-bound manner. Full stop. In view of the above, the presented petition is disposed of with the direction to the respondent to decide petitioner's representation within a period of 6 weeks. Within a period of 6 weeks from the date of communication of this order, after affording an opportunity of hearing to all the concerned parties. Full stop.
My lord,
With
let it be respondent number 8 to decide.
Respond number 8. Direction to respond number 8 to decide petitioners.
Yes, that's why I said.
It is needless to mention that the parties agree by such decisions shall be at liberty to challenge, shall be at liberty to take recourse in accordance with law. Full stop. With the above direction, the presented petition is disposed.
No, no, Mr. Ray is. He's recording.
Yes.
16.
Lordship, I'm on behalf of the petitioner, Lordship. Lordship, I'm praying for intra-district transfer, Lordship, because the petitioner is suffering from lower abdominal pain, Lordship. And I have to travel 80
Burman.
kilometers every day, Lordship.
Actually, the answer is West Bengal Central School Service. They are not a. No, inter. Sumit Kumar. Who?
The chairman, West Bengal Central School Commission. Who's the answering respondent?
Lordship.
No, DI.
Lordship, DI. Respondent number 5, Lordship.
Who appears for the DI?
I am appealing for on behalf of the, but they have to take the final decision. Central School Service.
Who will decide the representation?
Lordship, DI. Respondent number 5.
DI will forward to West Bengal Central School Service Commission. They have to. It is a matter of transfer.
May I? This is a prayer for transfer for medical ground and it's for intra-district transfer, Lordship.
Yes.
So the petitioner has made a representation that has been forwarded by the school to the DI. DI is one who shall take opinion from the CMOH of the concerned district and then he shall decide whether to allow this.
Malad, I generally appearing on behalf of the Central School Service Commission, but I have not received the copy of the brief.
Lordship,
But since the petitioner has made one representation, Malad, first, there is a prescribed pro forma in the rule in which the application should be made before the school authority. And school authority, after taking opinion of the BOMH, Block Medical Health Officer, if justified for transfer, then the school authority will issue NOC and then it will be forwarded to the district inspector of school for further course of action. And after receiving the copy, application from the school authority, the district inspector of school shall verify the records, medical records, by re-examining his case by the CMA, Chief Medical Officer of Health, and then, my lord, only district inspector of school.
Sir. That is the
Lordship,
process.
and that has been annexed, Lordship. Kindly come to page number 18.
18.
School has forwarded my application direct to the
18.
DI.
No,
1A.
it will no coverage.
Annex to P5 therefore.
Page number is different.
Page number is different. 19.
Malad, the application must contain the report of the BOMH, Block Medical Health Officer.
It has been, petitioner has made this application through the headmistress. That is the concerned school, Lordship.
No,
Concerned school has to send it to the
Lordship.
DI.
Lordship.
You
And
don't
here-
make it to the DI.
Lordship.
Where is your letter to the school to refer it to the DI?
Lordship, here Lord petitioner has written this.
No,
Sir, you
petitioner
can't
to
do
DI.
that. You have to follow the procedure.
Lordship.
Follow the procedure.
Through school it has been
But
done.
in this matter, Malad, may I suggest one thing, Malad?
Has to submit it first at her school.
Exactly.
Then school shall send.
Exactly.
Here in this case, Lordship,
So it's wrong.
yes, here he
All right.
has written through school.
So withdraw this and do the correct procedure and then come back to the court.
Give me the
Learned
liberty,
counsel for
Lordship.
the petitioner seeks to withdraw the present writ petition. Say the same is dismissed as withdrawn as the petitioner has. उससे पहले the petitioner states that he has not approached the school and has directly written to the DI for the intra, right?
Intra-district.
Intra-district transfer, full stop. Learned counsel for the petitioner states that he shall take appropriate proceedings in approaching the school, which inter alia will forward the application of the petitioner to the director of DI.
Malad, district inspector of school, Malad, of the concerned
Director
region.
of School, full stop. Learned counsel at this stage, learned counsel for the petitioner seeks to withdraw the present writ petition to the same is dismissed as withdrawn.
And Malad, kindly give me the liberty to file that. Otherwise.
Petitioner has the liberty to file appropriate proceedings in accordance with.
Obliged, Lord.
Over item number 7, my lord, Mr. Sunit Kumar is for the council.
Item number?
7, my lord.
Maladina.
Wait, let me, at 1 o'clock.
17. I'm for the petition.
Yes.
Central GST use. I've served, it is a,
Why here, Mr. Rai?
I, despite appeal permission, why I come? I covered by your lordship there. I brought it. Your lordship will consider my lord. Yeah, my lord, I have challenged the detention process under 129 and the order.
Where is he? Miss Sarkar? Who's there in this matter?
He is central state. Yes. The central is.
Who appears for CGST, Central State?
Mr.
Banik.
Bonik and Mr. Dikar.
Where are they?
I have served one.
Mr. Rai inform them so that we can, you have given a copy to them?
Yes, sir. I talked with him also. Mr. Bonik sir, he is not, Mr. Dikar or maybe.
We'll keep it tomorrow, let them come. What is your ground?
Ground is that they have not made out any case that I have intention to evade the tax. 420 cases, first point. Second one, they have measured the goods on the which is not prescribed in the statute. Then they have said for the OMN street, which is a statute document, they took for the driver. This is the weight of the gross weight of vehicle and the goods, and this is the unladen weight of the vehicle. So this difference is your.
Oh, this is difference is some 100, 400 something.
420.
420.
This is my lord. This tax is 5,000. And come another one.
So you should, what is, see, these are disputed things. You should go
But
in the field.
they procedure.
Mr. Rai.
There's no tax emission. No tax. It's 1.7%.
So why can't you go in appeal? Why should?
But it's absolute. I place your lordship judgment. I place the Supreme Court also. So absolutely jurisdictional notion. But how they have exercised this power? I'll show my lord.
Let Mr. Agarwal or Mr. Banik come. We'll keep it tomorrow.
Yes, ma'am.
You please inform them so that they're here.
Yes.
Tomorrow?
Yes. The 16 May is detained, my lord.
Tomorrow?
Next, sir. Yes.
We'll have it tomorrow.
Next, same.
Same,
18.
same issue also?
Same.
Same issue.
Only oops.
Same violation of the rules?
Yes. They can't say what's the violation.
No violation, you are saying that the measurement they could have not done, which they have done, right?
Yes.
That's what you are saying.
There is a officer over state. Just test it out.
Tomorrow, both these matters too.
19. I'm for the.
Well, at 19, I appear for the respondent.
So, lordship, can you come to page 41? 1 moment.
41.
I'll go in.
Yes.
My lord, WBIDC
Yes.
execute an agreement, unregistered agreement, it starts on page 38. Can you come to page 38?
Yes. Yes.
2nd March 2009.
2nd March 2009.
Enter agreement for grant of sublease of this property. Now you also can come to clause 5 at page 41.
Yes.
Clause 5 says, execution registration deed of sublease will be done when called up by the corporation. Allotee shall bear the cost of stamp duty and registration fee payable in respect of sublease.
Yes.
But this is a clause that they would now agreement, then they would give the grant of sublease. Now clause 6 says the agreement. The corporation shall hand over petition of said plan to the allotee after execution of this agreement, which the allotee hereby confirmed. Now, my lord, when we come to clause, this is my lord, at page 41. I can see clause 2 also. Clause 2. Sorry, clause 2.
Yes.
Allotee has paid the corporation sum of rupees 45 lakhs. I have paid the 45 lakhs. Then, my lord, they have now you're when it comes to clause page 47. Page 47. Yes, 47 clause 10 says,
Yes.
this is my lord clause, this is default clause, if I could not make the construction and start commercial production within 30 months.
Yes.
So then they can one extension, then they can. This is the agreement, is unregistered agreement. Now my lord, see, they have given me, my lord, they have given me the position that single land is at place 50, this is 2.069 acres of land. This 50 is a single land.
Yes.
This is land of 2.069 acres.
Acres of land, yes.
Now my lord, come to page, this is 51. They have given a position letter.
Yes.
They have given a position letter immediately. 52. Yes, position letter.
Yes.
Then minus what happened? Some private parties, and come to page 54,
Yes.
private parties file a suit
Yes.
in respect of land. This is admitted fact. This is they have land, so the land has been litigated.
Yes.
They shoot at 2009, as you can see, page 54.
Yes, I have.
Should have been filed.
TS
Then
number
they-
133 of 2009.
Yes, they made the one of the directors party, they did not make the WHC party.
Yes.
Shoot was going on. My lord, then what happened, my lord, since the property was litigated, I could not get any loan and nothing. And my question that WHC has not come forward to add themselves a party and to vacate or to free the land of the, they did not any steps. Ultimately, my lord, the suit was dismissed on
3823.
59, 58.
Yes.
My lord, they were in slumber. So 9 to 23, they are in slumber. Because all of a sudden, they have given a show cause notice. 26 December 2023. They said you have not taken any steps. They have also given me the registration of the sublease. This show, they have given the show cause notice.
Yes.
I gave the reply.
Page 62.
Yes, I give the reply. These are my lord facts, but I'm coming to the reply. Then my lord, personal hearing was given me at page 65.
Yes.
They have given me personal hearing. Then my lord, they have.
Page 66, you were supposed to
Yes.
submit building plan.
Now, this is all. They said it's a minutes. See my lord, how unreasonable. 2nd February 24, I've been asked. The unit, my kind of, it's not very nice. Unit will submit building plan to the corporation within 3 months from the date of this letter and will apply for all such grants to concerned authorities. The unit will complete the construction work and start production within 12 months from the date of approval of the building plan. So they have given the 15 months time and it's subject to the sanction of the building plan. They have not said anywhere that I have to take now. It's on online system. They have not said me. My youngster is in the agreement is given 30 months time. They have not followed it. They said, no, why you have not done for this? My lord, this, my lord, my instruction. Then my lord, kindly come to page 71. Page 71, paragraph 4. We have not informed that I have to submit by through online. They have not said. But page 71, paragraph 4. We have submitted building plan to the office. This is the of the state direction. We have already attached the building plan. We have got the money. This is on 6 May 2024. Because I didn't know. Next, my lord, again, and by this letter, my lord, I also asked them to grant me sublease, to register the sublease.
Yes.
Then they have asked me at page 73 to pay the lease rent. Page 73, I have paid my lord lease rent. This is payment is page 74. Then my lord, again we wrote to the 21st May, the officer, that we have at paragraph 4, we have given you the building plan. We could not upload it because of KC building plan. They have submitted. Now, my lord, at page 77. This is how cause of action starts. They have given me a notice for cancellation of allotment.
Yes.
Why they say, and can you come to page, next page,
Yes.
at page 6, paragraph 6, page 78. As far as you have informed the competent
Corporation.
inform the by letter due to unavailable of GST, you are unable to submit the building plan online. They have not denied that I have not submitted the building plan, but I could not submit by online. Page 78. Then, my lord, we made a representation page 79. Now, my lord, now they have given an order at page 84.
Yes.
Now, 84, this by 16 August 2024, they say you will submit a building plan for your proposed industry within September 2024. They have not denied that I have not submitted a plan. They have not said, but it was not submitted online by September 2024. And next step, within 8 months, I have to make the construction, start production. Then after this, my lord, so you can come to page 85.
Yes.
We are 13 September 24, we submit because now the fire license is required, my lord. We submitted for fire, we talked with the consultant, law officer helped me, she advised me to go to the consultant. 13 September 24, we applied before the online for fire license.
Yes.
Now, my lord, can you come to page 90? On their online, we submitted the building plan on 25th September 2024.
Yes.
So by September we have applied, filed. But these are online system, actions are given. So my lord, within September we have filed. They can't deny. Now, my lord, can you come to? These are all system, my lord, portal showing. My plan is at page 95. I uploaded.
Yes.
Now, my lord, now can you page 96? Scrutiny report of building plan. It was generated by their own portal. This is on 5th October 2024. They have said, but can you see, there are some, what I should do, they have said at page 102, summary of the note sheet. This is some fire light, this is the requirement for the fire engine. These are all required. At page 102, last, they are WAC's officers have advised us that these are required.
102.
Yes, 102. This is part of security report of building plan. It's a continuation, one.
Yes.
These last two, 32 items.
32 requirement for fire engine. book.
Need movement, driver with, and these are some the technical things, my lord. Now, my lord, page 103. By this time, fire cleared, they have demanded notice, they demanded the notice for 8 May 2008, March 2025. Page 103, my lord.
Yes.
My lord, we have paid the money, we have paid the fees. Next week, we paid the fees.
Yes.
Now, we are waiting for fire license and we will submit it. So it is on process. My substance that we applied within 24 September 2000. I'm not going to the earlier facts on the basis of their requirement we have submitted. Now at page 107, they're given the letter of 20th February to 25 that they resume the land and get 107, 108 on the ground that I could not submit the plan within September.
Yes.
So on record. Now, and immediately, now they have, we intimated them, they have issued a notice at page 123 for that the corporation invited proposal for entering an eligible industrial house seeking allotment of available land for industrial purpose which areas industrial park corporation and district which were Jalpaiguri, I am in Jalpaiguri, and they are showing in their my land is at next phase at 4 available. As soon they have resumed it, it is available. So there, my lord, I specifically stated, my lord, some independence review, they are interested, my lord, they're trying to hand over this. Now, my lord, my first point is, you have made an agreement, my lord, I just sum up my argument. My lord, you have entered an unregistered agreement, you are a state authority. There is a litigation from 9/2/2023. My honorable answer, what steps you have taken to provide me the unlitigated land? I got the suit was dismissed 2011, they filed, my lord, they filed a deed petition also, I am not gone for compensation on the private parties, so it was litigated. Ultimately, in 23, it was free of encumbrance. Immediately given the show cause notice, I have answered.
Yes.
You have not sent me, you have to file on online because now, my lord, this is dual, so one window system. And he said, how the non-application of minor is, they say you have not filed it by September 9, 2025. My document shows I have filed it. It is under process. Now they have already made, they are in so haste, even they have made an advertisement to settle this to somebody else. But this is absolutely illegal, my lord. Secondly, my lord, they can't take steps until unless, but they have also not, they can't explain why they have not, they took me more than 47 lakhs. But last, they have not executed the grant of the registered sublease money. This is my sister, this is absolutely illegal. But I just pressed to judgment if it was studied.
Is it required?
I'm also trying to, I read it. Because this is,
No judgment will place, it will go against.
that I know, you will have here.
No, it's not. The answering is on screen.
What is the proposition you are trying to show?
But these are settled positions. Again, how many it is? Actually,
What proposition? Tell me, Mr.
these are arbitrary actions of the state.
Arbitrary action.
I want this place because can you allow me?
Yes, yes.
The two judgment boards. 2002, 2023, 2 SCC, 7 years period. 2023.
What land has been redeemed in this? What is it? They have taken. What are the facts?
2 SCC koto?
These are facts are different.
I know, but what is the proposition you are relying on? Para?
I just, my lord.
23, 2 SCC?
SCC 703. But it starts from paragraph 53. All the judgments are quoted. Ultimately, my lord, the some of these at page paragraph 75. Like your Surfacey, something paragraph 75. You see got it, man? It starts from 53. All the judgments are, my lord, quoted. Now, we would therefore sum up as to when the act is to be treated as arbitrary. The court must carefully attend to facts and circumstance the case. It should find out whether the improved decision is based on any principle. If not, it may unerringly point out to arbitrariness. But there is no, they have not followed any principle. If the act betrays characterized or mere exhibition of the will and the authority, it will be sufficiently bear the insignia of arbitrariness. In this regard, supporting an order with a rationale which the circumstance is found to be reasonable will get a long way to repeal a challenge to statement. No doubt the reason need not in every case be part of the order as such. Even it's not the order. Here you can see they are sleeping. Sleeping. If there absence of good faith and the actually with the oblique motive.
They are saying you are sleeping.
You were sleeping. I was not sleeping.
No, their allegation is you are sleeping.
Well, I show your documents.
I know, but their allegation is that.
They are trying to say that, but they have not taken any steps to non-litigate it. They have taken money from me.
I'm not saying this.
That
The reason is a rationality.
That I understand.
The judgment is a rationality.
Yes, that I show.
Yes.
My lord, no doubt that resist need not in every case be part of the order. If there is absence of good faith and the action is actuated with an oblique motive, it could be recognized as being admitted.
তাহলে এই টিম বি টিম করে মামলা এই টিম বি টিম করে মামলা মামলা
Yes.
that civil
Yes.
suits
Why should?
Arbitrary. I got it. Anything else?
No, I got it. The other
Yes. Yes.
the
Lord, I appear for the respondent number 1, my lord.
Yes.
My lord, with regards to the suit being filed, my lord, what my learned friend has not indicated to your lordship. Initially, there was an order of injunction which was vacated way back in 2011.
2011.
Yes.
Yes.
There is no restraint on him to take steps pertaining to that particular property. That's one. From 2011, he took no steps. 2014, my lord, we intimated the district magistrate that there should be no impediment in the petitioners taking steps pertaining to this particular property. 2014, we also intimated them to take steps to have the property mutated in the name of the petitioners. They took no steps. Now, my lord, when after issuing a show cause notice, we told them that you have not taken steps for 18 years. Now you come and try and do something. They say that yes, we'll take steps immediately, and we granted them 15 months time. In those 15 months time, they were supposed to submit their building plan. They could not do that, my lord. We terminated the agreement. Upon termination, they say that no, we could not submit the building plan because we don't even have a GST registration. Thereafter, my lord, upon their request, we kept the termination in abeyance. We told them that you have to submit a building plan and you have to complete the construction of your industrial setup within 8 months from 1st November 24. My lord, now they allege that it was incumbent upon us to intimate to them that the building plan has to be submitted online and not through a physical copy. Unfortunately, my lord, even then, despite of giving them time till September 24 to submit the building plan, they did not. What they did was they submitted a physical copy on 25th of September 24. What they show your lordship at page 96, it's a scrutiny report. It's not the submission of the building plan. If your lordship kindly comes to page 96.
Yes.
That is the scrutiny report.
Yes.
It's right at the top of the page, my lord.
Yes.
And they do not indicate to your lordship that they have only given a scrutiny which has been returned with a query. It is not as if the building plan has been sanctioned by us. It is at this juncture, my lord, we come back in February 25. We want to put it up for an auction. We want to exploit, and so that, my lord, the state coffers are filled. For 18 years, you have sat tight over this.
Yes.
And, my lord, they have not disclosed any of these letters written to them from, my lord, 31st March 2014 up to 2015, asking them to take steps. This have not been made part of the writ petition. I do not know under what pretext or under what circumstances. They go ahead and, my lord, come up before your lordship. They file this writ petition, do not disclose the complete facts, and they say that kindly stay the auction. Lord, it's my humble and deepest request. If they want the money back, we are more than willing to return the money. 45 lakhs was paid in 2009. It is not today. They have put in the money for the fire license. It is their obligation to put in. They have done it. But that doesn't mean, my lord, I'll be held in ransom and I'll be prevented from taking steps in accordance with law. The agreement stands terminated because, my lord, the notice of resumption has already taken effect. Apart from that, my lord, the letter by which we had indicated that the termination shall be kept in abeyance, it was a conditional abeyance upon them fulfilling the conditions provided in that particular letter. They have failed to do so. Lordship will kindly, my lord, either permit me to put in on affidavit all these particular points, along with, my lord, the documents which they have not disclosed in the petition. Otherwise, it would be my deepest and humble request, my lord, if your lordship may please to dismiss the writ petition. If they want to take back,
You put, I'm sure you don't want to take the money back.
No, wait.
Not at all.
My-
So you put everything-
Answer, why they have not executed the deed of service? Can you answer it? Yes, bypass it. Is a state
Because-
order. Page 41.
All right, you file your affidavit.
My
In
lord.
the meantime, don't take any action.
My lord, that will prejudice the entire process, my lord.
I'm not only regarding my, I'm not in the.
Take down. The petitioner has preferred the presented petition being aggrieved by A. The notice dated 20th/6/2024 for issued by respondent number 1 for cancellation of allotment/assignment/termination of lease. Full stop. B, the order dated 20th/2/2025 for resumption of the land. And C, the public notice dated 16/5/2025 inviting proposals from eligible entrepreneurs for the allotment of 2.069 acres of land allotted to acres of land previously allotted to petitioner number 1 company in Dabgram Industrial Park. Full stop. Respondent number 1 corporation entered into an agreement dated, what is the date? 2nd of March 2009 with petitioner, wherein the petitioner paid a premium of rupees 45 lakhs 51,800. Full stop. Subsequently, 1 Bajiruddin and others, and 2 others, three others instituted a title suit number 133 of 2009, seeking an injunction restraining petitioner number 3 from seeking an injunction against seeking restraint against defendant who's the petitioner in the present case, seeking an injunction restraining the defendant who is the petitioner in the present case from carrying out any construction on the said property. This is it, Mr. Rai?
Should put the title and injunction. See? Sorry, should put injunction.
Injunction. Just injunction. Not for suit for declaration.
But these are some of the own land they can.
Page 56. All right, injunction. Take like fire. But Mr. Bajiruddin, the erstwhile owner of the said premises from whom respondent number 1 had acquired the said land, also initiated writ petition number 5209 of 2015, which was disposed of by an order dated 26/3/2025. Due to these pending proceedings, the petitioner was unable to utilize the said land.
I not get the bank finance, the litigated property.
You could respond number 1 issued show cause dated 26/12/2023, calling upon the petitioner to explain why the allotment should not be cancelled on the ground of non-utilization. Full stop. The petitioner submitted a detailed reply dated 10/1/2024. Full stop. A Personal hearing was thereafter granted, comma. The respondent number 1 prepared the minutes of meeting dated 22/2/2024. Full stop. The said minutes of meeting recorded that the petitioner would submit a building plan within 3 months, comma, comply with all statutory requirements, comma, and complete the construction within 12 months from the date of approval of the plan. Full stop. A total of 15 months was granted for completion and commencement of the project. Full stop. Pursuant thereto, comma, the petitioner submitted a building plan to the corporation on 6/5/2024, comma, which was acknowledged on 9/5/2024. Full stop. The petitioner also paid the annual lease rent of lease. How much was the annual lease rent? Annual lease rent of rupees?
Yes.
43,000.
40,946.
43,946 on 16/5/2024. Full stop. Despite compliance, comma, respondent number 1 issued a notice of cancellation dated 20th/6/2024. Full stop. The petitioner responded with a detailed representation dated 6/7/2024. A further personal hearing was held on 4/8/2024 and a MOM minutes of meeting was circulated on the same day. Full stop. As per the minutes of meeting, comma, the petitioner was directed to resubmit the building plan.
Not some, yeah, not this is on some.
Submit a building plan to resubmit. First is you were granted resubmit the building plan by September 2024 and was granted an extension of 8 months for complete construction and for complete construction and commence production. Full stop. The revised building plan was submitted on 25/9/2024. Full stop. Subsequently, the corporation raised objections, comma, including the requirement of a safety recommendation. Full stop. The petitioner deposited the amount quoted by the fire department, comma, and the recommendation is still awaited. Full stop. In the meantime, comma, the respondents passed the order of redemption on 20th of February 2025. Full stop. Thereafter, a public notice dated 16/5/2025 was public auction notice dated 16/5/2025 was issued, comma, inviting proposals from individuals interested in reallotment of 2.069 acres of land originally allotted to petitioner number 1. Full stop. Learned counsel for the respondent, Mr. Ghosh, submits that the petitioner had entered into an agreement with the respondent in the year 2009. Full stop. On the pretext of a pending litigation, the petitioner has not utilized the land in terms of the conditions prescribed under the agreement, full stop. He further states that the injunction granted in the litigation came to an end in the year 2011, and thereafter also the petitioner did not take any steps to utilize the said land, full stop. What else, Mr. Ghosh?
Lord, they had submitted a building, they were requested to submit a building plan within a specified period. They failed to do so. They initially applied through a physical form, which was not accepted. They were aware of this process.
That I've already recorded.
Well, apart from this, my lord, they didn't have a GST registration because initially when we terminated the contract, they asked for recalling of that. In the recalling notice, they admitted they do not have a GST registration as well.
The respondent further submits that the petitioner the petitioner had no GST registration, and it shows that the petitioner was not inclined to carry out any activities in terms of the agreement entered with the respondent. Anything else?
My lord, the building plan which they have tried to submit, it is in the form of a query. It is lying for scrutiny. It's not been accepted.
The learned counsel for the respondent further submits that the building plan submitted by the petitioner was not in accordance with the regulation, and that the building plan was more in the form of a query rather than in the form expected by the respondent corporation, right?
And yes, my lord. And lastly, my lord, they have not disclosed 4 letters which we had written to them way back in the year 2014 and 2015.
Learned counsel for the respondent further states that previous communications have been withheld by the petitioner in the present writ petition, and that the respondent corporation has been periodically writing to the petitioner to utilize the said land, and has been pursuing with the petitioner to act in terms of the agreement entered between the parties, full stop. He further states that the present action has been taken since the petitioner has failed to comply by the terms of the lease, by the terms of the agreement entered into between the parties. Anything else?
Lord, we had also written to the district magistrate to ensure that there is no impediment in, my lord, the petitioners taking over the land. And
that you bring it on record. All right.
We will, my lord. And also, my lord, we had requested the petitioner to take steps to have the land mutated in their name.
You know, executed the alphabet, my lord, fancy, my lord, they have executed the deed of sovereignty.
Take down the
Well, I'm only praying, my lord, if your lordship directs me to put in the money, I'll put in the money. But my lord, the auction process should lordship kindly consider. For 18 years, my lord, they have not utilized.
All right, take down. This court has heard the submissions by the parties and has perused the materials on record. Full stop. Upon perusal of the record and consideration of submissions made, this court is of the prima facie view that the petitioner was prevented from utilizing the allotted land due to circumstances beyond his control, including protracted litigation initiated by third parties and the pendency of requisite statutory clearances. Full stop. It is not in dispute that the petitioner deposited a substantial amount of rupees 45,51,800 towards land premium as early as in the year 2009, and has made subsequent efforts to comply with the conditions as stipulated by the respondent authorities. Full stop. In view of the above, comma, and considering the balance of convenience and irreparable injury that may be caused to the petitioner in the event of further proceedings pursuant to the impugned order and public notice. This comma, this court finds it appropriate to direct the operation of the order of resumption dated 20th of February 2025 and the public notice dated 16/5/2025 shall remain stayed for a period of 4 weeks. For a period of 4 weeks, you'll file your reply?
We'll file within 2 weeks, my lord.
Yes, for a period of 4 weeks from date, full stop. Learned counsel for the respondent seeks and is granted 2 weeks time to file his affidavit in opposition. Reply to the same within 1 week, list after 4 weeks.
Grateful.
Take one more. We have time.
My lord, serial number 20, I am for the petitioner, my lord.
Take the password.
Oh.
Take. Yes. Password. Yes. Password. Mr. Chaudhary was not there. Password matter, you were not there. No. 7. First 7.
Well, I don't know, two.
Which is the matter? First, take
Item
the first
two.
Passover in accordance with. Which is the first Passover?
Item number 2.
Take 2.
And from
Who's there in item 2?
Well, they are not appearing, my lord.
All right. The petitioner had not appeared in the first call, even when the matter is taken up on the second call at 1:13. There is no appearance on behalf of the petition. The present writ petition is dismissed in default.
Yet full.
Worship, I will read my extraordinary management, Lease like in principal bench, number 20 and 34. That's the.
Sir, in the morning you said
Yes.
he is not able to connect. Now argue the matter. Yes. Argue the matter. Tell me.
Worship, I'm not aware of the complexities of this.
Tell him to come after lunch. All right. Can't avoid the court like this. Password. 3 and 4 password, madam. Let him come after lunch.
He is not connected.
I know, but the lawyer is the same. I know it's not connected. Tell him to come after lunch. We'll take passwords after lunch. Tell him to be here. Yes.
For the state, my lord.
Yes. What is there in this?
The school service commission.
My lord, I am appearing on behalf of the School Service Commission. My lord, I have inquired from the office of the School Service Commission till date, my lord, they have not received the brief. But till date, my lord, the petitioner has not served the copy of the writ petition upon the
don't
School
you
Service
serve?
Commission.
What is the problem? He says you
My
are
lord,
not
I have
served the-
received,
Yes.
my lord, I personally requested the learned advocate appearing for the state to send the copy of the writ petition. My lord, unless the office receive the copy of the writ petition, I am unable to, my lord, receive any instruction, my lord.
You try your luck on Friday. Serve him a copy. You please send your email in the chat box. The counsel for the petitioner will send you a copy. Please come with
My
the.
lord, chat box is stopped by the learned office of the court, my lord.
I will
My lord,
ask.
we cannot.
You
We
do it.
cannot. We cannot.
Allow it. Allow him to put his email ID in the chat box. Allow him to put his email ID in the chat box and share it with the petitioner's counsel. Okay, give it to him. Put your email ID.
Yes.
Right now, put it.
Yes, my lord.
Put your email ID. Mr. Roy, type it.
My lord, I cannot, my lord, unless they are
We
allowing
have
me, my
allowed
lord.
you. We have allowed you, Mr. Roy. Type it.
Yes.
Advocate SUNIT roy@gmail.com.
Jamie. A copy of her report.
Mr. Roy, keeping it
Yes, my
for
lord.
Friday, take the instruction, come on Friday.
State's report.
Grateful, my lord.
We'll have it on Friday. Friday.
Grateful. Grateful.
Rest of the matters after lunch. Yes, Mr. Chaudhary, which one is yours?
After this.
After lunch.
तो ब्रेकडाउन कर क्लियर अभी मुझे समझ में नहीं आया आप लोगों ने क्या कहा मैं चार्ट थोड़ा सा किताब खोजूंगा अपना दिमाग लगाऊंगा कल के आएगा बोला तो मैं दिमाग लगा कि नहीं बस दिला नहीं बस हमको लगा हमने किया आपको जो लेना है ले लो जो करना है वो कर लो उसको मतलब हम लोग इतना पॉइंट्स दे दिए प्लीज वर्जन एक ही साथ क्या प्लीज दो के है वो सब चीज को सामना वहाँ भी है एक्चुअली दैट वहाँ भी एक्चुअली कंडीशन इसीलिए तो लोग का एजुकेशन है यहाँ पर बाद में देखो तो एक चिट्ठी किया प्रॉपर प्लान तो फॉर्म भी दिएगा कुछ भी नहीं किया because that is for enough problem तो बायोडाटा में भी बहुत जरूरी है तो मैं टाइम तक भी रजिस्टर हो गया था बी रजिस्ट्री में इधर फॉलो कर जो एबीएस का जो बी रजिस्ट्री किया था वो कर दो मार ले हम जो से आया सब एक इस ऊपर मतलब एक हमको बहुत सारा जो है देखा भी तो पड़ गया ये हाल गिर जम गया था आपको as per this methodology, इसको हराने में पॉइंट सही है तो हराने के लिए पॉइंट सही अब वो जान गया है कि हम तो रहेगा तो ऊपर जाए पॉइंट तो section हम लोग को दिखाना चाहता था लेकिन भारत का उसका दूसरा रोटी खा रहे हैं पहले चाउमीन जो है मैं सोच रहा था चाउमीन यहाँ पे बाकी का चीज का तो बात में दूसरे फ्रेंड को जोड़ के रखा फिर जोड़ रहा है सब तब वो जोड़ के मैं भी सोच रहा था बहुत कुछ है हम लोग कुछ नहीं है फिर बात का फोटो कौन हो रहा है एक हरा वाला एक लाल वाला था ठीक है फिर मैं ये सोच लगा कि इसको इसमें मिला के खाए इसमें मिला के दिल्ली में पहली बार सिंपल चाउमीन चिकन सिंपल चाउमीन अलग अलग टेस्ट को आने लगे चिकन अलग और चाउमीन আমি যেটা দেখা দিচ্ছি यहाँ तक आके आलू पराठा खाए अच्छा लगा ये सब चीजें अच्छा है ये सब चीजें अच्छी Batsman now. এদের কমিশনটি হলো বেজেস আর আমার উপরে আগার আর্টিকেল 41 সুপ্রিম কোর্ট ওই জায়গায় পাইছে এর জাজমেন্ট ট্রান্সফার করা চলবে এই হলো কথা একটা এখনই আমি প্রশ্ন করি গরম জল বসে গরম জল বসে বাড়িতে বাড়িতে আসি না পুরো পরিষ্কার করে দেবো শোনা যাও শোনা যাও আমার শুনে জানেছে তারপরে এখনো কোয়ান্টিফাই আমাদের কাছে একটা পাউডার আর আমাদের আমার শুনবে কি আবার এত কাম করতে এরপরে কি নিয়ে আসছে না না এটা লাভ কি বলে ঠিক আছে বলেছি যে That is what I class. That thing was a class. Very The extra status But I console it's like super exercise can be delegated apart from
My lord, I'm appealing.
Yeah, what is the problem, Mr. Banerjee?
My lord, it has been muted. My lord, am I audible, my lord?
Yes.
My lord, the item number 3, the writ petition, pertains to, my lord, the lands which are part of the Darjeeling Improvement Fund. Look, this is an old construct created by the British, my lord, for improvement of the surrounding areas in and around Darjeeling. Well, the policy is that these land cannot be transferred or converted to freehold lands, and nobody can claim ownership of these lands. These are given on leasehold basis for a maximum period of 30 years. Now, the petitioner before your lordship is such a leasehold landholder. Now, what has happened, my lord, the petitioner's lease is not being renewed, citing the transfer, the Bengal cabinet has okayed the transfer of this AI fund land to the RR department in the year 2023. Citing this, my lord, the renewal has been stopped, but the existing persons who are leasehold, these are all leasehold properties who are existing, their wards and spouses are being recorded as riots in the RORs. The RORs have been attached. If you see page 25 onwards, these properties, the ROR shows that these have been converted to personal properties. Their status is being shown as riots. This is not permissible under the policy, and if it is being done, it is being done illegally. Because the record of rights clearly shows all these which are part of the fund are being converted. Not only there, but the petitioner has also attached a deed which shows the lands are being transferred. It has been sold off, somebody is purchasing, and this name is not as own. All these are illegalities which are being perpetrated within this domain. All these relates to the development fund, and these cannot be fixed. But I will be humbly beseeching my lord, if your lordship kindly calls for a report from the concerned officers of the state government with regard to this. What is their policy? If there is, because the cabinet has okayed a change in the policy, but that is not notified and that is not available. And if these are being converted, that is something else. If the government has okayed the freehold usage of the lands, the old policy has been done away with, fine. But if that is not being done so, these properties are being sold off and malls are being created, commercial complexes are being created, and persons are claiming personal rights over these properties. This is the grievance of it. There is a topic.
The Darjeeling Improvement Fund is a separate fund wherein it was created during the British era. It is admitted, created during the British era for the improvement of land areas and plots in and around Darjeeling. But this particular land now pertains to the district of Kalimpong after the subdivision of the Darjeeling district into the district of Kalimpong. Now, what the petitioner claims is that there were these parts of this DI Improvement Fund land has been recorded in the name of certain possessors as riots. But that recording is absolutely erroneous. That I have stated in my report. My lord takes up my report. My lord takes up the second page, my lord. That is the point number 3. OA number 2338, my lord. OA number 2338 of 2003, if I may read the relevant portion. Kalimpong Riot Welfare Association, there was a there's an original application filed. Yes. Versus the state of West Bengal and others. It is worthwhile to mention in this respect that the West Bengal Land Reforms and Tenants Tribunal order, this is the WBLRTT's order, dated 18th May of 2006, passed in OA number 2338 of 2003 in the matter of Kalimpong Riot Welfare Association and others versus the state of West Bengal and others. Respondents held that the provisions of the Estate Acquisition Act and Land Reforms Act shall prevail over the fund rules, that is the DI fund rules, in areas covered by the fund rules, where the fund rules are contrary to or inconsistent with or repugnant to the provisions of the Estate Acquisition Act and the Land Reforms Act. It further states all actions taken in all orders, notifications, circulars, contract on settlement issued or made by the authorities and others which were or are in violation or in breach of the provisions contained in the Estate Acquisition Act and the Land Reforms Act are illegal, invalid, and bad in law. So, from a basic
What is left, Mr. Banerjee?
My lord,
It has already been held to be null and void. All the conversions are held.
And my lord, one more point, my lord, if I may agitate. My lord, regarding the record of rights which have been erroneously mentioned, my lord takes up the point number 6 in the next page, my lord. The claims and allegations under the heading, the claims and allegations in the writ petitions. My lord, the claim of the instant writ petitioner is that her lease was neither renewed nor lawful patta was issued in her name despite her repeated requests. That is the claim of the petitioner. My lord, what has been stated by the authorities in this regard is that certain irregularities on the part of the Land and Land Reforms Department along with others in maintaining the record in respect of the DI fund land has been noticed. After noticing such irregularities, what action has been taken, my lord? The next page. In each of these mutations pertaining to DIF land, what was done by the revenue officer concerned, empowered under the provisions of the West Bengal Land Reforms Act on the basis of Khasra Khatian, submitted by the applicant concerned, issued by the DIF section. As has already been stated in the foregoing paragraphs, that there were some inadvertent omissions in entering the status of the DI fund leases during digitization of the land records, owing to some technical issues. There were the software in which these mutations were carried out, certain portions of the software didn't have the relevant columns. That was the problem during digitization. Specifically, the Basat Proja status of a DI fund leasee could be entered in the remarks column under Nuton Khatian Puron, tab of Khatian Sangsodhan, menu of e-Bhuchitro after entering a new Khatian. Against that, there was no option to enter the remarks Basat Proja under mutation application tab while entering the mutation cases for updating the land records through gift, sale or succession. This might have led to the recording of the applicant as Rayat. And that is the erroneous recording which, my lord, the petitioner is referring to. That is the erroneous recording as Rayat. This cannot be as Rayat. This can be at the most as a Basat Proja. And my lord, these are the cases particularly which have been referred in the table below. WR relates to Warish cases, the mutation cases which have been granted in favor of any particular petitioner on the basis of legal heirs as being the legal heirs, and MN relates to mutation cases by virtue of sale or any transfer of land by virtue of registered deed. And my lord, on the next page, I have already submitted that in order to do away with the inadvertent omissions and with a view to effective management of the DI fund land, the concerned authority has imposed restrictions on mutating the DI fund land as well as the development area land, and has time to time solicited guidelines in this respect. The Department of Land and Land Reforms and Refugee Relief Rehabilitation Department, through letter bearing memo number, my lord, this memo is attached with the writ petition. This memo, my lord, would find at the end of the writ petition. My lord, it is already enclosed with the writ petition. That is a restriction specifically imposed by the Assistant Director of Land Reforms, and the communication has been made by the district magistrate, my lord. It is addressed to the and these are the restrictions that have been placed in mutating the said lands of the DI fund. So the government, the government's view is that this because of the erroneous recording, no rights can be accrued in favor of those persons as riots. This is merely an erroneous recording admitted by the land department, my lord.
So they are admitting it, Mr. Banerjee?
My lord, two things. My lord, may I be handed over a copy of the report? And number two, my lord, if your lordship takes page 35, the sale deed. Well, these are contradictory submissions. My lord, I could have understood, my lord, how can the sale of the land which is part of the Darjeeling Improvement Fund be done? As because there is no freehold right, as because there is no right, it is not a personal property, you are just a lessee. How can a person transfer and sale of these rights? And these sales, he is referring to the deeds of sale and is changing the mutation, the record of rights. How can these be permitted? He is referred to have attached that has come up only in the year 2018. The notification was published by the DM that no more registration. But what about these which are part and parcel which have been done away with earlier? This could not have been done. These lands could not have been sold because at best, as per the policy, the person was holding the land as a lessee for 30 years, subject to renewal. How could he have sold parts of the property? These are being done, not just a single deal. These are being done. And they are saying that is a erroneous error in the record of rights because of the software issue. Well, that could not have been. They could have rectified. The petition is pending.
On affidavit, my lord. I intend to file an affidavit.
Why your connection is so bad, Mr. Banerjee? You are making the court struggle to hear you.
My lord, I deeply apologize, my lord. I am not doing this on purpose. My lord, I am doing this from the main building of the Calcutta High Court. Perhaps that is because of the issue, my lord.
We don't care where you are appealing from.
Maybe that is the.
But for last 2 days, we are struggling with you. We are just struggling. We can't hear you. And today also we can't hear you.
Under my unconditional apology, my lord. In my video,
your juniors are not prepared.
And I can hear
you are sitting from the same place and I can't hear you. Take down. Due to bad connectivity, let this matter be listed before the next available second bench. Learned counsel of the petitioner is inaudible due to bad nothing. Due to bad connectivity, let this matter be listed before the next appearance. Give back the report. Madam, I can't hear him. It's a struggle. You are saying it. It's impossible to follow what he's saying. He's the same lawyer. Same order.
I am for the state, I can say.
Just can't hear him. You are also sitting here. Can you hear him? If you can hear him, you decipher and tell me. Same as 3.
Password matter 12. Yes, I'm for the petition. Okay. Well, this is for consideration. I was in occupational because of land point.
Yes.
And then government response decided to make a construction of bridge on the canal of the Usta barrage. This is minor Gajol. Then minor. And they have made a joint inspection report. Joint come to page 17. That's 17 minor.
Page 17.
These all of the occupiers are there. Page 17 starts with page 17 joint inspection report. My name is at I come to page 20. These are all the list of occupiers. Page 20, my name is at number 2. Dulal Dotto, 4 figures of land. Page 20. This is the report. It's got it one.
Yes.
On the basis they have offered me a stall at page 21. This is their policy, they have taken decision for stall they have offered me. Which is what is my page 20. But that has not yet been given. And then I made a recommendation. And the BLRO, the video wrote a letter to again at page 24. You might say, at page 24. What is one? Video wrote in my favor to the director. And now by this, these are all has already constructed by her. But we have found that out of 4 figures, 3 figures land remains unutilized. So I make a representation, my lord, the authorities concerned at page 29. That page 29 and up to page 31, I said that if you could not give me the stall, this land name is unutilized, kindly settle me in terms of government policy at page 25. Starts the page, my repeat the page 29. And paragraph 9 is my basic demands that I have ventilated. And I say that this land policy is there at page 25. The government can settle the unutilized land, listed land. This policy I give at page 25. This is my only for my consideration.
Yes, Mr. Chairman.
My lord, this is completely is admitted fact is a 4 acres land, a vested land. And whatever in this train use in occupation or enjoyment, that is my lord, the undetected, my lord. Because definitely something if it is a vested land.
But why you have not given him the stall till now?
My lord, this stall, my lord, I have to seek instruction whether it has been stall has been constructed or not. Which is proposed to be that my lord,
That is the ground on which you have taken the land of the petitioner.
My lord.
The land of the petitioner has been taken, acquired.
It is not the petitioner's land. It's a government land.
Government land, they have all been holding you, or you yourself have come up with the policy that you will be granting them shops. The allotment letter you have issued. Till date, you have not allotted it.
My lord, this is the reason I am saying, because the land which has been utilized is not his land, it's the government land, number 1.
That's all right,
Number
whatever
two,
it is.
The government has given a proposal for providing a stall. So this is the reason, my lord, I have no
Let us use the
instruction whether
word-
these such stalls have been constructed or not. Unless the stalls have not been constructed, my lord, the question does not arise for allotment,
You seek instruction.
my lord.
So shall we keep it for Friday or?
Next circuit, my lord, I'll definitely.
Either stall or.
No, no, my lord,
land must be-
if
See, land is not yours.
No, I can't say. I said, this is policy is there. I give the
that would be
policy.
the future prospect.
No, policy is there.
Policy is there for future prospect.
Can you page 25 is land policy?
Yes, land policy, it is utilized, it will be.
They can consider only. If without you guys, I'm not, it's not my matter. I
Because
said,
they
it's
would
not my
like,
matter.
by way of this consideration, they would
So
like
it's
to
not
shield that. This
So,
code, this,
yeah,
my lord, the armed with this code, they
Just
say-
a minute, both of you can't speak at the same time. Yes,
Yeah.
what are you showing?
At page 20. This is
Page
land policy.
23,
Page 25.
25, yes,
This is state government has taken a policy.
yes.
This is unutilized land of western line that can be settled on a long-term lease value. This is Roman 3. This is the policy. I says, either you give me allotment of stall or I've seen that these lands are unutilized or 3 acres in place of 4 acres, I can consider it as per this policy. They may take, may not reject my claim. My rights have been approved regarding stall. You can't give the stall. He said that because may not be constructed. Roman 3 is the one relevant portion of that.
The
policy.
petitioner has preferred the present writ petition being aggrieved by the inaction of the respondent authorities in not allotting a stall. ब्रैकेट में कर दो कैटेगरी हाइफन ए स्टॉल नंबर 2, 250 square meters at market complex at Borealo. Market complex Borealo at Borealo. It is the case of the petitioner that the petitioner was in lawful occupation and possession of 4 bighas of land, having pond therein at Gajoldoba near Borealo, block Rajganj, PS Milanpalli district, Jalpaiguri. Full stop. Respondent authorities have taken over. The respondent authority took a policy decision to construct a bridge over TMLC. Bridge over TMLC, right?
Yes.
Yes,
TMLC.
Yeah, TMLC.
At Gajoldoba and establish a market at the same site. Full stop. The respondent authority promised that the persons affected by the said evacuation process will be allotted stalls in the proposed food court.
No, it is not an
No.
acquisition process, my lord.
Sorry?
It is not an acquisition process.
Evacuation,
Evacuation, sorry. I mistakenly.
not acquisition.
Evacuation.
Evacuation process. Stalls. Full stop. Stalls at the food court, right? Stalls at the food court,
Market complex, my lord.
at the market complex. In the proposed market complex,
Yes.
full stop. The Deputy Director of Tourism, Department of Tourism, Regional Complex, Regional Tourist Office, Siliguri issued memo dated 27/6/2019 in respect of allotment of stalls.
Provisional allotment.
Provisional allotment of stalls at market complex near Borealo in the name of the petitioner.
Subject to construction of that, my lord, the project. If you see, my lord, the first paragraph,
Yes,
project will be completed within the next 6 months. It is proposed project.
Yes.
First paragraph.
Idea is
where are you reading?
My lord, the madam sir, in reference to the above,
Got it.
my lord, in that page 21.
Yes. Provisional
will
allotment,
complete
Order
this
and mark.
by 6 months.
Yes, the construction of this project would be completed within a period of 6.
6 months. They
So
say.
this is the reason is the
There-
provisional, that time it was not constructed.
You have given the.
He is in anticipation.
in respect of provision allotment of stocks and vehicles and wherever in the name of the petition.
In the name of the petitioner. Petitioner's stand is that the bridge has already been constructed and is operational, but till date, he has not been allotted the said stop, full stop. Despite representations, the respondent has not taken any decision on petitioner's allotment of stop, full stop. Learned counsel for the respondent seeks and is granted 2 weeks time,
Yes, my lord, sufficient.
2 weeks time to file report by way of an affidavit.
Any exception, ma'am?
The reply exception to the same within 1 week thereafter. List after 4 weeks.
Grateful.
Continue item number 20.
My lord, 20, I am for the petitioner, my lord. File number 20.
Yes.
For the statement.
The petitioner serial number 2, my lord. My lord, matter about my lord, permit of the IPL, my lord. My lord, on February 24, my lord, the respondent number 2 and 3, after conducting the board meeting, issued my permit on my lord 19th May 2024, my lord. Kindly, my lord, paragraph 9 at page 9, my lord. Paragraph 9 at page 9, my lord.
Hey, Manoj.
That your petition.
Wait. Follow. Yes.
My lord, paragraph 9, my lord, that your petitioner states that 19th May 2025, respondent number 2 and 3 should permit file number 2B 025 AC 86A being verification number WB 63D 0225 and on which respondent number 2 and 3 have mentioned number of day single trips allowed to. Kindly come to page 35, my lord.
Where are you appearing from?
My lord, from Calcutta, my lord.
Your voice is not clear, sorry.
From my residence chamber, my lord.
You get a better connectivity. The problem is your connectivity are so bad that we have
Last also, my lord, same problem, my lord. Network problem, issue, my lord. But my own house, my lord, that is the installed, not my lord. Are you audible, my lord?
Sir, in between you are not audible. It's very difficult. We have to let this matter be. The petition is not audible. Same order, sir. The question is inaudible. Let this matter be listed before the next available.
My lord, 21 also, my lord. On behalf of petitioner, my lord, 21.
You don't have a better connection.
My lord,
In the house, is there any position where you get better connection, sir? You go there.
my lord, about minutes password, my lord.
Tomorrow, let it be tomorrow. Tomorrow. We'll have it tomorrow.
We also have to take instructions in this matter. This is supposed to appear on 19th. They have
Nine-
given us the letter saying that it will appear
Tomorrow we'll have it.
I need some more, 1 day more accommodation for instruction, or day after tomorrow if possible.
Day after tomorrow.
Grateful.
Day after tomorrow. Day after tomorrow.
Lordship. 21 or same, my lord.
Day after tomorrow.
34 and 35, my lord, also same, my lord. 34 and 35.
At the time when we call out, then you have.
Oblige, your lords.
Yes.
22.
Yes, Lord. I'm appearing on behalf of the National Highways.
These are, you know, they mention these matters and get it listed.
Yes, Subhasi says, he
Who's there?
was.
I'm for the state, my lord. Mr.
ছিল তো এখানেই ছিল
None appears for the petitioner. Though the present matter is listed on mentioning, none appears for the petition. Let this matter be listed before the next
Hello, state and
available.
national higher.
Give your appearance. Next available circuit bench.
Twenty-three.
23, my lord, I'm appearing for the petitioner, my lord. My lord, am I audible to your lordship, my lord?
Yes.
My lord, the petitioner before your lordship, my lord, is the district president of the party in opposition in the district of Kuch Bihar. My lord, we have an innocuous prayer, my lord. My lord, on the 25th of June, my lord, from 12 o'clock to 6 o'clock, my lord, we propose to hold a Tiranga Yatra, my lord, to celebrate the success of Operation Sindoor, as well as, my lord, in honor of the army personnel, my lord, who were taken part in such a operation, my lord, we propose to organize a rally, my lord. Lordship may kindly sees, my lord, paragraph number 3 of my petition. My lord, I've indicated the date and the time of the rally, which I propose to hold, my lord, as well as the route. It will start from Sangati Moidan, Dinata, to Dinata Panchmata Mode. My lord, as your lordship, my lord, got it?
Yes.
My lord, the details with regard to the rally, my lord, is at paragraph number 5, my lord, where I've indicated that there would be expected 3,000 participants, my lord, and that there would be 20 vehicles, my lord. They would be mostly four-wheeler vehicles, my lord, as well as loudspeakers will be there and microphones will be there. My lord, the leader of the opposition, along with other dignitaries of the party in opposition, my lord, would be participating in the said rally. My lord, the route is about 2 kilometers to 4 kilometers, my lord, in length. My lord, there are sufficient space. My lord, may kindly thereafter takes up, my lord, page number 26 of my application. And my lord, the page thereafter, page number 27, my lord, I had informed the officer in charge of Dinata police station, my lord, under whose jurisdiction, my lord, this rally is proposed to be held. My lord, this has not been responded to till date. My lord, we have given the indication as per this honorable court's, my lord, judgments previously also. Who are the persons who will be the coordinators? What are the exact time? When do we start? When do we end? What is the route taken and what we propose to do? My lord, the route would be Shangati Moidan to Dinata station, to Sahibganj roads, to Dinata Panchmata mode, and then a street corner meeting, my lord. So we have given everything, my lord, in detail. My lord, this has not been responded to till date. Now, my lord, just to point out to your lordship, my lord, my learned junior, my lord, may hand out an order of this honorable court, my lord, which has been passed in similar circumstances. My lord, your lordship may kindly sees order dated 25th of January 24, WPA 1790 of 24. My lord, last year also, my lord, Tiranga Yatra was proposed to be held, my lord, which was declined by the state respondents. My lord, this honorable court, my lord, has permitted the rally to be held. My lord, upon certain undertakings, my lord, which your lordship will find in the judgment itself, my lord, that there were certain undertakings that we will not block any emergency vehicles and other, we will not cause inconvenience to the public at large, my lord. These are my prayers, my lord, before your lordship. My lord, upon usual undertakings, my lord, we are ready and willing, my lord, subject to your lordship's, my lord, granting us the permission to do so, to allow and hold this particular rally. My lord, because, my lord, otherwise, my lord, this is the basic essence of a democratic, my lord, foundation, my lord, of the state of West Bengal. And, my lord, we belong to the party in opposition, my lord, which is why we have to run to the court, my lord, to allow us such permissions.
Yes.
My lord, there was no refusal from the state's end.
Yes.
Your lordship sees there is a representation.
So you decide his representation.
Yes, my lord, and also, my lord, the state administration difficulties, my lord, the date which they have proposed on 25th.
Yes.
My lord, 27th is a Roth. So there is be a huge, my lord, with regards to the administration, my lord, to maintain a law and order. So if they can
decide his representation.
My lord, I would be only beseeching, my lord, they will, my lord, what they will do,
they can reschedule the date, my lord, with intimating to the concerned person, so that eventually also we are working for that, my lord, even.
My lord, if I can just respond to
then
that,
there will be no collide, my lord.
He has made a representation. Why didn't you decide it?
My lord, we are deciding, my lord. It is not a
no, my lord. My lord, this is the, my lord, consistent. My lord, I've got thousands of judgments, my lord, where rally, my lord, we have to approach this honorable court. My lord, they will not decide. what they do, my lord.
They will
is that they-
decide. I will give a direction. They will decide in 2 days and communicate to you.
My lord,
The petitioner has preferred the present writ petition being aggrieved by the inaction of the respondent in not deciding.
my lord, only one prayer, my lord. I'm sorry, my lord, to interject your lordship,
Yes.
my lord, at the time of dictation. I got frozen for a bit, my lord. My lord, my only prayer is that today, my lord, they have come up with the plea that a Rath Yatra is held on the 27th of June. My lord, I'm holding this on a day schedule on the 25th of June, my lord,
That's
from
right.
12 o'clock to 6 o'clock.
Yes,
Yes,
see,
sir.
the ground which they are saying, it doesn't really make sense to this court. Let them decide the representation. If you are aggrieved, you come back to the
My lord,
court.
then a time period may be fixed of, my lord, at
I
least 2 days,
am.
my lord, so that my
Yes.
lord, I can approach this honorable court again.
Absolutely.
Deeply grateful, my lord.
Petitioner's representation dated 11/6/2025 submitted to the officer in charge of Dinhata Police Station, where the petitioner sought permission to hold the rally bracket with Tiranga Yatra on 25/6/2025 from 12 noon to 6 p.m. starting from Sanghati Maidan, Dinhata till Dinhata Panch Matha Mode. Panch Matha Mode, full stop. Learned counsel for the respondent submits that the respondent will take final decision on petitioner's application dated 11/6/2025 in 2 days. In view of the aforesaid submission, the writ petition stands disposed of
2
with
days,
a,
including today,
no, 2 days from tomorrow.
today and tomorrow. Tomorrow and day after.
Tomorrow and day after.
Tomorrow and day after.
Yeah.
2 days
Today is 17. Well, kindly specify within 20.
within
20.
by
Then I will not have much time, my lord, because seeing the submissions
today
today,
17th, 18 by 19th.
deeply.
19th to
But the
working.
circuit bench will not be from the next subject to correction because I have only Friday.
Mention before the principal bench. What is the big deal?
We
My
are
lord, the
not
problem is
denying.
that today we are already.
That definitely
By
will
the
allow
time the
an
principal
SSC.
bench sits, my lord, it will be 21st.
So,
Will take decision on the petition's application by 19th
Deeply.
of June. In view of
make it,
the,
my lord, kindly make it 20th, my lord. Kindly make it a 1 day.
That will be prejudicial for me, my lord.
Concentrating to all.
Because
It is
my lord,
not
today the
reflecting.
submission is an indication. The submission
Today
is an indication that they are going to refuse
Wednesday.
it.
Thursday, Friday, my lord, we will communicate.
19th by 19th. By 19th. You take a decision by 6 o'clock. What is the difficulty?
Yes, deeply.
We have the whole 19th. In view of the aforesaid submission,
1 day more, my lord, 3 days. 1 day more. I will. It may communicate within 19th also.
by 20th.
My lord, I would be beseeching 19th only. They are going to refuse it because they'll say that 27th is the Rath Yatra, which they have indicated right now only. My lord, before your lordship.
What we
They
will
have
do?
indicated that only. My lord, in their submission.
Today 17.
Yes,
Let
my
them
lord.
act 2 days. It's okay.
By 18th and 19th. my lord. By 19th night, let them communicate to me.
by 20th, it's fine.
Yes, my lord, definitely.
In view of the aforesaid submission, the presented petition stands disposed of with the direction to the respondent to consider and dispose of petitioner's representation dated 11/6, right?
Yes,
11/6/2025 within by 20th of June and communicate the outcome of such consideration to the petitioner immediately thereafter. Full stop. Accordingly, the presented petition stands disposed of.
Deeply.
Lordship, I have everything on behalf of the applicant also.
Yes.
So the attachment is filed in time, Lordship, there is no delay. So let's give a direction, next directions.
What is this FMAT?
For 11.
Without any delay, right?
No delay.
Saurabh, same order.
Grateful, Lordship.
Yes, Lordship, in this case, there is a defect, Lordship. I have not filed the statutory deposit of 25,000, Lordship.
You are the petitioner?
Yes, Lordship. Lordship, kindly fix it on next circuit, Lordship. In the meantime, I will file the statutory deposit.
Learned counsel for the petitioner states that learned counsel petitioner seeks some more time to remove the defect
Yes, Lordship.
and prays for this matter to be listed before the next available circuit bench. Full stop. Let this matter be listed before the next available circuit bench.
I am appealing for the petition of motion.
Who's for the respondent? State. State of West Bengal, who's there? Mr. Paul? You're not there. Up here. Who's there? You have a list? Matter is marked to whom?
Mr. Pritam Das is for this take.
Mr. Pritam Das hardly appears.
He was there, Malord.
Was there? Oh, yes.
For
he
item
was-
number 20, he was
yes.
there.
Yes, you make
My
this
lord,
one.
kindly see page number 9. Annex
Page
52,
number 9.
9 of my application.
Yes.
That is my representation, my lord, to the chairman of North Bengal State Transport Corporation.
Yes.
Actually, my lord, the case is concerned, the present petitioner husband was a co-keeper of India's list.
Yes.
Somehow, he was succumbed to his injury in the railway track on 8/9/2019. My lord.
Yes.
Then I prefer a representation to the chairman to give a pension benefit. But my representation was turned down and no communication was done to the present petitioner. My humble prayer, my lord.
Where is the representation turned down?
My lord, there was no communication towards
There's
that.
no so you have made a representation.
Yes, I have made the representation. That is page number 9, my lord.
Where's the legal air certificate?
My lord, I have not.
So how will they
Yeah.
consider it without the legal air
My
certificate?
lord, I have a marriage certificate that is on.
Marriage certificate will not do, sir. Legal air certificate you have to give.
Actually, my lord.
Apply with the legal air certificate, they'll consider.
Then, my lord, I kindly give a direction to file a supplementary affidavit, my lord.
Supplementary affidavit, you'll produce the legal air. You have legal air certificate.
Then I have to communicate with the client because
So, sir, you come back, withdraw this, file with a legal air certificate. You have to move an application with a legal air certificate. How will they process it?
actually, I have to communicate because she can have that certificate.
Ask her. I'm not dismissing it. Come back tomorrow.
Yes.
27.
I'm appearing for the petitioner, my lord.
Yes.
Lordship, this is a GST matter. Now,
Yes.
at the very outset, before Lordship gets into the thicks of the brief, let me open my submission by saying this, that the whole act is an aberration and horrendous usurpation of jurisdiction. The
Very-
state GST has no jurisdiction. Why I say this? At the very first instance. My lord, here, admittedly, by both the sides, here, the goods were being transported from Jharkhand to Meghalaya. Before Lordship gets into the brief, I'm just outlining narrating the story. The goods were being transported from Jharkhand to Meghalaya using state of West Bengal as a corridor. Admittedly, there is no stake, no revenue stake of the state. They have never said that this was tried to be clandestinely or surreptitiously sold
But
in
I
the
think
state
this
of West
matter has
Bengal.
been listed or mentioning, right?
Yes, yes,
But
yes.
we wanted his goods to be released. I think that is the ground of urgency.
Milord, now though he has already given the full amount of penalty and
Then
got the
exactly
goods released. Actually, there were two matters with this. One, this, and the other one was another matter, Milord Jogeshwar Shah. Both were mentioned before your lordship together. Since they entail the same point, in Jogeshwar Shah, Milord, I needed the release. So anyway, my lord, let me place this case. I won't take much of your lordship's time. In fact, this has appeared many a times, but the main matter had never been appreciated, or rather, the chance did not come for the court to appreciate the merits. I think my learned friend is also ready. Here, my lord, yes, here, my lord, what has
He is
happened?
always ready.
Yes, my lord.
That's very cooperative of her. I have seldom heard her not ready. So, my lord, what has happened here? These goods were being transported. These goods were going for a job work. Why job work? My lord, it's a machinery, huge machinery, earth excavating machinery. I have given it on rent to somebody else in Meghalaya. I am situated in Jharkhand. The state of West Bengal never says that its revenue was in disarray. It never says that I was trying to sell it in West Bengal and therefore I was trying to hoodwink the revenue in West Bengal. They have, on a purely technical basis, apprehended the goods where they had no jurisdiction at all. Here the goods was originating from Jharkhand, going to Meghalaya. Maximum they could have done, they could have informed the authorities so that they can take the appropriate course of action. Now, what is the technical violation impugned herein? The first violation is this: I have used no tax invoices. True. And moreover, in case of no tax invoices, Rule 55 says I should have a challan, more specifically a delivery challan. Here in my case, my challan was designated as job work challan. That is it. There is no other third limb to their allegation. Now let me clear out on the issues why I did not have a tax invoice. My lord, section 31 subsection 2 of the GST Act, it makes it very clear that only upon the supply is completed, it becomes a taxable event. And here, this was not a case of supply of goods. Here, these goods were being sent as an article which is rented out. And upon that renting out, they are supposed to pay me rent. So unless they get this article itself, this earth excavating machinery itself, so they will not, there is no contract, there is no lease. Lordship knows much better than me, my lord, that this is a deemed sale. Rather, this is a deemed supply as per the Constitution Amendment and all the authorities of Gannon Curley Builders Association, age old. Lordship knows. So this, my lord, what entails is, unless I have my goods delivered there, I am not supposed to get generate the invoice. Then it will be actually a flouting of the provisions of the Act. So there was no tax invoice. But in order to show my bona fides, my lord, I had enclosed the tax invoice of my purchase. That is to say, I purchased this excavator from somewhere and then I am sending it for the purpose of renting it out. I have enclosed that tax invoice, that e-waybill, etc. Here the waybill was also there. And thereafter, my lord, the delivery challan. Here, my lord, I must say, there was a small mistake on the part of my accountant. What was the mistake? My lord, the thing was, the article was going for the purpose of doing a job work. So, my lord, mistakenly, he just designated. Mr. Bhattacharya, this requires hearing. This will take time. Let me run through my board. Pass it over.
My lord. My lord, then I will wait for the day, my lord.
Yes, wait.
Grateful to your lordship.
Madam.
28.
Madam, for the petition. Am I
My lord,
audible?
28. 28, my lord, I am appearing for the state respondent, my lord. Am I audible, my lord?
Yes, madam.
My lord, am I audible? Yes.
Yes, madam. Yes.
I'm for the petition.
Deeply obliged, my lord.
Yes.
My lord, before my lord going into the merits, my lord, I will humbly submit, my lord, to produce the order dated 8th January 2025, passed by the coordinate bench of this High Court, my lord. There is a gist of the matter, my lord. My lord, kindly go through, lord.
Yes, what is the status of the release of the money? Mr. Burman, are you appearing? What have you done, Mr. Burman? Release the money. What has happened?
The case is that they were initially paid the money through check. They failed to encash.
That's recorded in the order.
Present, we filed a affidavit stating that at present the system of payment is through letter of credit.
Yes.
He is not enlisted, that is the problem. However, we have written to the higher authorities for releasing fund in our ways, considering the situation.
So release the money. Why you're not releasing the money?
No, money can be released, but since there is present mode of payment is through letter of credit.
So do it through letter of credit.
We have written the.
No, what do you mean written? Where is that letter?
We have annexed with our affidavit.
Well, there are several communication between the departments. I have annexed in the writ petition as well as they have annexed in the report filed by them. And this is a matter of 2012, my lord. 13 years, my lord.
It has been withheld. He failed to encash, that is the problem, and now.
So release the money, Mr. Burman. I understand. Why you're not releasing the money? Where is the letter? Annexure?
Letters, several letters are there, including last. Annexed.
Kindly take page 23 onwards of the report, my lord, which they have filed, my lord. Page 23 onwards, my lord. May I show from the writ petition, my lord? If my
Yes,
lord
yes.
Yes. Grateful, my lord. My lord, I will read first come page 22 of the writ petition, my lord. My lord, the division officer first communicated to the principal chief conservator of Forest General, West Bengal, my lord. May I read, my lord?
Just a minute.
Whatever. He is not enlisted.
Page 23 also, there is another communication, my lord, between the department, my lord.
So who's not releasing the money?
No, the problem is not releasing because he is not working. He is not enlisted.
Mr. Burman, what are you saying? You have admitted it.
Yes, payment has also been made long.
Mr. Burman, the payment was made through check.
Lordship.
He could not encash because his daughter was not well.
Lordship.
Today you have to make him the payment. Don't make excuses on this, Mr. Burman. These are not cases to be contested. Please have some sympathy for people.
We have written for releasing.
So that's what I'm asking you.
Lordship, then response number 2 may be validated because they have to allow.
And subsequently, daughter of the petitioner died also, my lord.
They worked long back of 2011. That is the problem.
There is no problem. Problem is you.
Yes. And Pedali is also not enlisted.
Maybe, my lord, but I have worked in the year 2012, my lord. 9 July 2012, my lord, I have informed them first through representation, my lord. 9 July.
Show me the facts.
Yes, my lord.
Take me to the facts.
Yes, my lord. Well, kindly come to page 20, my lord, the work order, my lord. Page 20. My lord, got it?
Yes.
Yes, my lord. May I read, my lord?
Yes.
Subject, work order against the tender notice such and such of project such and such. Reference, your tender dropping on 20th January 2012. This is in reference to your rate offered against tender notice such
All
and
right.
such
So
regards
you
project
completed
number
the
such and
work.
such for.
Move ahead. Move ahead.
Yes, my lord. Well, my lord, then my lord, the communication, my lord, which I have shown already, page 20 of my lord, between the departments. Sorry, my lord, page 22 onwards. Sorry. And the first representation, my lord, which I have made on 9 July 2012, it is in annexed by them in their report, my lord.
Sir, you tell me from your
It is at my
petition, please, Mr. Karan,
Yes, my lord.
can you please narrate the facts
Yes,
clearly?
Yes, my lord. This is a work order, my lord.
I've
I've
seen
seen.
the work order. Move ahead.
Yes, my lord. My lord. In my lord, I have annexed at page 22 P5. The divisional forest officer, my lord, addressing to the principal chief conservator of forest, stating that, my lord, kindly find herewith a prayer of the petitioner, my lord, of Kathambari, which will speak for itself after completion of project work. Such and such check was issued in favor of the petitioner of rupees such and such by check number such and such dated 30th March 2012. But unlikely he was not able to encash the said check in due time. He prayed that he was out of station in case of treatment of his daughter, and so could not deposit the check in the bank in time. In this connection, it is point out that the said amount was in the budget provision of 2011-12 in HS such and such building.
Mr. Karan, where are you reading? Which
Page 22 of
Page
my read petition.
22, page 22 is the letter written by the divisional forest officer for payment of the
Yes,
bill.
ma'am. Yes, ma'am.
Where is your representation, first one?
First one, my lord, it is annexed in their report, my lord. Which I have misplaced, my lord, but they have annexed in their report at page 18, my lord. Page 18 of their report.
Please
Sorry,
see
my lord, I
page-
have misplaced it.
Please see
Yes, my
page
lord.
26.
Yes, ma'am. Coming, ma'am. Yes, ma'am. 26, 29th June 2015, my lord. Prior to that, my lord, I have also written, my lord. Page 25 also my representation, my lord. It's dated 12th March 2015. And my lord, page 29, death certificate of my daughter, my lord. Then again, page 30, my lord, again their communication, my lord, for the release of the amount by the divisional forest officer to the principal chief conservator of forest, West Bengal. Now, my lord, page 31 is the letter which I have written to them for the completion certificate, issuing of the completion certificate, which has not been issued in my favor. And thereafter, my final representation, my lord, on 29th October 2024, which is starting from page 32 of my lead petition. My lord.
Thank you. Take down. The petitioner has preferred the present writ petition, seeking payment of arrears of dues of rupees 2,87,532, along with interest at the rate of the petitioner preferred the present writ petition seeking so and so along with interest at the rate of 12% per annum. It is the case of the petitioner that he was awarded work order against tender notice number 2/budget/BKP 2011-12 of project number 1/build/SPAP of 11-12 for construction of Group D quarter at Targhera range under Gazaldoba beat of Bakanpura division. Full stop. The petitioner completed the said work and was issued a check of rupees 2,87,532, white check number 073598 dated 30th/3/2012. Full stop. Petitioner states that his daughter was unwell and later on passed away on 2/7/2015 due to the ill health of his daughter and due to unavoidable circumstances. He was not able to encash the check in due time and accordingly the check lapsed. Full stop. Since then, the petitioner has been making various representations to the respondent authorities, but till date, he has not received any payment. Full stop. Mr. Burman appears for the respondent and states that a report has been filed by the respondent authority wherein they have admitted the issuance of the check number 073598 dated 38/3 for an amount of rupees 2,87,532 in favor of the petitioner. He further states that the said amount is an admitted amount, but due to insufficiency of fund, the said amount has not been paid to the petitioner.
Not, not insufficient for he could not encash, but subsequently, since it relates to old fund work of 2011, subsequently introduction of letter of credit system.
All right, what are them? He states that the petitioner he states that due to introduction of a new system of payment, letter of credit system, the check could not be issued to the petitioner, reissued to the petitioner. Full stop. this court notes that these are only excuses for not making the admitted payment to the petitioner. Full stop. It is disheartening to note that though the petitioner had completed the work in the year 2000, when was the check issued?
12, my lord.
30th March 12.
In the disheartening to note that the petitioner had been petition was issued the check in the year 2012, 30th of March 2012, for completing the work in terms of the tender. But till date, the payment has not been released to the petitioner. Though it is unfortunate to note that the petitioner, due to unavoidable circumstances and due to the ill health and later demise of his daughter, was not able to encash the check issued in his favor. Full stop. The respondents are directed to release the payment to the petitioner within a period of how much time? How much time?
8 weeks.
Within 4 weeks, they are directed to release the payment in favor of the petitioner within a period of 4 weeks without any delay. Full stop. If the same is not done, the petitioner will be entitled to an interest of 12% on the delayed payment after 4 weeks. Full stop. With the above direction, the presented petition is disposed of.
Different.
Grateful, my lord. Grateful.
29.
Takes up this matter, if you'll also kindly sees the prayer, whether the cause of the writ petitioner is still alive or not. Her prayer for childcare leave was not considered. Accordingly, this writ petition was preferred, my lord. But the time for which she sought leave is already over.
Now, what do you want? What do you want? That period is over. What do you want now? Childcare leave is gone. That period is over. Writ petition becomes infructuous.
Prayer was for washing the same, say, order, whereby the.
Sir, even if the order is quashed today, that period is over. All right. So this has become infructuous. If you want to claim any damages, file a suit for damages.
She was on the leave. She took the leave.
Yes.
He was on the leave,
Yes.
and it was not considered.
She had already availed the leave.
She was on the leave. Yes.
Mr.
That was unauthorized, my lord.
Then there is a cause of action. Then we have to see whether the leave is
She did not wait for that. She approached this honorable court.
whatever it is.
My lord.
Pleadings are complete.
Pleadings are completed, my lord. My lord, the school is the necessary party. The school has already filed their opposition and they have replied to that.
They had filed the report
Hmm.
in the form
School.
Who appears for the school?
opposition.
Who appears for the school?
School.
DI.
No, it is the response 4 দিয়েছে। না, না, 3 তো আমরা। We have 3, response number 3.
Report was given by respondent number 4,
We have submitted the report.
but no, we did not get any.
No, I see a opposition by the response number 4.
We did not receive that.
You have annexed in your.
But it is in previous occasion.
Oh.
The report, the affidavit we have
As well.
annexed, that is on previous occasion.
May I submit?
No, no, wait. Who are the relevant parties, sir? They are not here.
It's better if it's first day in the document.
Yeah.
Solve them again.
But actually, DI is also but
He is the president of the school. Secretary of the school.
Who's the secretary of the school?
DI.
The state is represented.
In his official capacity. Who appears for the school?
And 4 is the headmistress.
Who is DI is the president. He is DI is the secretary. And 4 is the administration. The administration did not appear, but who else appeared?
You have who has passed the order? The impugn order is passed by?
It was not
Passed by-
considered.
Passed by DI.
No, it was not considered then.
Not considered, and the annexure in page 71. The note has been given. Detail.
We'll see it tomorrow. I don't have time. We'll see if tomorrow we have time for hearing. I already have one matter. Not today. Not top of the list. For what top of the list?
তুমি একটা কপি নিয়েছো দাদা?
What problem? You have already
Take it.
unauthorized leave. What problem you are facing? What problem are you facing? What is the problem? That's better.
No, she has already taken 526 days leave.
No, that we have contradicted and we have filed the
No, it-
affidavit in
The
opposition.
leave is not of as of right now.
If I allow it, your salary will be cut. If I find that the leave is unauthorized, they'll deduct the salary for all that period. We will see that.
Yes.
Grateful.
My lord, I am on behalf of the respondent.
Yes.
My lord, my affidavit in opposition is ready. My lord, this is not stitched, my lord. I'll just stitch it and file it, my lord.
Yes.
I for petitioner, lordship, in last occasion, state filed to affidavit in opposition.
Yes.
My lord,
You have a copy?
my lord, I've, sir.
Affidavit in opposition is filed by the state. The same is taken on record.
My lord, it is not stitched.
Stitch it and
I'll stitch it and I'll give it.
stitch it. Is taken on record. I'm just recording the submission. in it.
Just now I'll do it, I'll do it.
This guy. Is taken on record. Learned counsel, the petitioner seeks time to file exception. 2 weeks time to file exception. Seeks and is granted 2 weeks time to file exception. Let this matter be listed after.
I'm grateful.
After 4 weeks?
My lord, after 4 weeks.
After 4. Yes.
I am for the respondent, your lordship.
What is this?
Today I am paying for adjournment on the
This is
ground.
the- Who was appearing? Somebody was appearing. This matter was listed yesterday also.
Yes, that was another matter.
What are you seeking here?
The
You are nobody, by the way. You are nobody. You are a trespasser. You have entered and your ground is that the workers have allowed you to trespass.
Yes.
No,
Yes.
I have entered into an agreement with the workers trade union in the office of the assistant
All right.
commissioner.
You want me to dismiss it? I'll dismiss it. List before the next available circular. What right do they have, workers have? You are just taking the law in your own hand, doing all things necessary, or illegalities. And then you come to the court with all thrust. Want a stamp from the court of all your illegalities. Who are the workers that they will give you? Worker association will give you right to property.
No, this one I am not claiming it. I am only claiming the registration.
First of all, who are you? You are a trespasser. Yesterday only I understood that issue. And if you want, I'll dismiss right away.
32 same.
Same matter.
Yeah.
33. These matters are listed after mentioning and nobody appears. Every day morning, Mr. Rai, and I'm allowing almost all mentioning. What is the point?
They are, it really that they are talking the crime, that they're very energetic. But they have come and
He doesn't need gun. We should have less gun in the market. Explicit default. Gun license. You are there.
34, I am for the petitioner, my
Where
lord.
were you?
No, 33 Lordship.
Where were you?
I was in court number 2 Lordship.
Huh? No, you are in 30?
33 Lordship.
Gun license.
Done like. The state was directed to file reports.
Mr. Barman, reply.
33. Well, 33, Mr. Rahman
One
is
can-
appearing,
don't
he is
let-
only in court number 1, man. Very short person.
The petitioner seeks further time to file.
The respondent Lordship.
The respondent seeks further time to file their reply. Seeks and is granted further 2 weeks time to file their reply. List before the next available circuit bench.
33.
Who appears?
Mr. Rahman, he is on leg in court number 1.
Or shall we keep it tomorrow?
My lord,
Not today.
grateful. And my lord, may I be permitted? This item number 31 and 32, myself and Mr. Rahman is appearing.
Give your
We,
appearance.
we are in, but the thing is that the report is with us. Totally goes against them. Because this DM has no knowledge about the garden, anything. They have not sanctioned anything.
That's why they chose not to. Next circuit. Next circuit.
You have no case at all.
Next circuit. See,
As your lordship.
he has no case. He knows it.
Or I'm shopping.
34.
My lord, 34, I am for the petitioner, my lord. My lord, I am praying for leave, my lord, to file supplementary affidavit, my lord, at a number 34, my lord.
For what?
My lord, subsequent event, my lord, I am praying for leave to
What
file.
subsequent event, sir?
My lord, matter about, my lord, permit, my lord, the issuance of the permit, my lord. My lord,
Permit, no subsequent event. Tell me what is the case.
my lord,
This is
case about,
absolutely a dispute between private parties. Nothing to be done here.
no, my lord, kindly consider my submission, my lord.
Yes.
My lord, is initially issue permit by the RTA authority Kuchbihar, my lord, to me, to the petitioner, for plying my vehicle, for carrying the student of the school private respondent, my lord. My lord,
Yes.
according to agreement, my lord, about 6 years agreement with the school, between the school and my petitioner.
That doesn't give you any right, sir. That agreement.
My lord, agreement between school and the petitioner, but my lord, the respondent authority, my lord, respondent number 2, the RTA authority, without, my lord, cancel my agreement or otherwise my permit, my lord, he issue another permit to the other vehicle for flying the school student, my lord, only. That is the main grievance of the petitioner, my lord. My lord, before issuance of the permit to other vehicle for flying the school
You
student.
want to challenge the permit granted to the other person, challenge it.
Yes, my lord, I have submitted my representation before the authority concerned, my lord. That has not been considered, my lord.
Sir, representation will not be considered. If you want to challenge that order, you challenge that order.
My lord, after submitting my lord representation, without hearing me, the authority concerned, respondent number 2 issued another permit, fresh permit to the another vehicle owner.
Challenge that permit. File another writ petition, challenge that permit.
My lord, leave to grant file, my lord. I withdraw this, my lord.
All right. Learned counsel for the petitioner seeks to withdraw the present writ petition. with liberty to file, with liberty to pursue his remedies as available in law.
Same order.
Same, my lord, same.
Same order.
I'm obliged. In this case, Mr. Rahman is appearing.
He is there, I think, in court too.
Not today.
What is there, Mr.
Lord, sir, this is the a claim of
Pension?
pension dues.
We'll have it tomorrow, not today.
Very long.
खत्म हो गया बोल hearing
Lordship, I am bringing for respondent, Lordship, Union of India, Lordship, learned DSG arguing council. But Lordship, learned DSG is suffering from illness last day. Lordship, kindly fix for.
Mr. So and so appears and states that the learned
DSG.
deputy ASG is
My lord, maybe
is not well. Is not well. He is suffering from high fever. Let this matter be listed before the next circuit bench.
Grateful, Lordship.
My lord, please. Tomorrow.
He is not well. He is asking for next circuit. Next available circuit.
Lord, I beg to appear, Lord, on behalf of the respondent number 7 and 8, Lordship.
As well as appearing, issuing that, my lord, with this sanction of bringing plan, the municipal law is mandatory in a principal market yield of the market committee. It is the issue.
Issue is sanction plan is required
for construction building.
Yes.
In the principal market yield
Yes.
of a regulated market committee.
Building plan should be everywhere wherever the municipality or the.
That is my point. If there is a government, that should be the point.
Lordship,
Yes.
yes, we are appearing for the Siliguri Municipal. Today we are appearing for the adjournment, Lordship. For
You are appearing for?
Siliguri Municipal Corporation.
They are the main authority.
Lord, I have got the Siliguri Regulated Market Committee, Lord. Already I have used my affidavit. Last question, there was a direction that there is.
Not reaction, I asked.
No.
You have a direction from your ground.
Hear me, what I am saying. There are certain queries where.
He always comes up with solution. So you should hear him. Yes, Mr.
But he says state has not given the.
That is-
That is said.
that-
I anticipate.
Yes, that I am saying. There are certain queries formulated by the court. My learned AGP was supposed to be, but I do not know what is the date of that.
State has not given the affidavit, although the court has given.
It was a long back, Milord, I have used one of the affidavit from the regulated market committee.
The state had sought time to file affidavit.
Yes.
Yes, and certain.
Who's appearing for the state?
Oh, now he's not talking. Now he's talking. He said,
Mr. Chaudhary, you also appear for state.
he has appeared.
Not already regulated market committee because the stands taken by the committee and.
So who's appearing for state?
They-
The order of the committee. Now, committee has.
See the order of 28th of April.
And then
You had sought time. Who?
What is taking?
Why you are not taking? Form that is pending.
why is that taking time, man?
Learned counsel for the state seeks and is granted
No, it is.
further time to file the affidavit as per direction of this court dated 12th of June 2024. Seeks and is granted 2 weeks time.
Started very well.
The issue is very fundamental issue.
Whether the building plan is required to be sanctioned or not. If it is the
See,
state.
If without the state it can be done, I'm ready to hear it.
Yes, it can be done.
I don't think so now. The states.
Well, they're taking-
I am not taking Mr. Ray, I appreciate it.
I'm not saying you. I'm not saying you.
Further extended 2 weeks, next available, sir.
Because otherwise it will be a,
My lord, can you take this matter, my lord?
How can I take it? They have sought time to file their reply.
Right there. You see,
What can we do?
Grateful Lordship.
my lord, they can give us some default clause, my lord.
no, my lord,
If
what
they
I,
not file,
what I will do, from my office, I will make all in the way.
can you give a default? clause?
Otherwise, it will not be, that I understood.
Can you give a default clause?
The state is granted one last opportunity.
Others.
One last opportunity to file.
Last.
No,
No, my lord.
All
the last lecture.
granted. So,
Last
He said, have me, what do you?
2 months.
Chuk. My lord, you know, High Court. So, you have.
I know you might be best of friends, but not in the courtroom. Not in the courtroom. In the courtroom, you can't use this.
No, last 3 matters, he said, I have a document, one of the matters called on, evidently he.
All right. Call out the next one.
Grateful Lordship.
With the 29 notable, I will see this matter because there is long.
will
Very
not-
important points are important.
Next.
I don't know,
39 Lordship, I am appearing for the petitioner. May I be allowed to appear
Yes.
virtually, Lordship?
Yes, madam.
Lordship, this is the matter whereby my Section 14 application has been rejected by the respondent number 2, Lordship. On the earlier occasion, your Lordship was directed to show your Lordship the interim order passed by the Honorable Apex Court, whereby it was the non-declaration of NPA was granted, Lordship.
You are appearing for the state.
Lordship,
What?
Lordship,
Yes. Yes, madam.
Lordship, my senior colleague, the local council would be there, Lordship, to hand over you the order, interim order date.
Today is here.
Lordship, I hope he has handed you the interim order, Lordship.
All right. Yes.
Lordship, kindly see page 7 of that order, Lordship. Interim order
I
dated,
have seen it, madam. I've seen it.
Lordship.
Yes, Mr. Barman. She had made her submission.
Subsection from the allegation that in view of the pregnancy of the matter, something the honorable Apex Court it was brought in their presence. We have not objected. We are directed to file fresh application. If your lordship directs that the earlier petition.
Take down. The petitioner has filed the present writ petition. Take down. The petitioner has filed the present writ petition assailing the order dated 31/1/2023 passed by the district magistrate, Cooch Behar in case number 28/2020, whereby the application filed by the petitioner under section 14 of the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002 bracket में hereinafter referred to as the Surfacey Act bracket close was rejected, full stop. The factual background leading to the filing of the present petition is as follows. So respondent number 3 and 4, the partners of SB Enterprise, had approached the petitioner bank at its Dinhata branch seeking credit facilities to the tune of rupees 1 crore 30 lakhs under the Kisan Mitra AVCP, all capital scheme, full stop. Upon due consideration, the said facility was sanctioned by sanction letter dated 20th/8/2008, subject to terms and conditions stated therein. Subsequently, on subsequently, comma, on 31/8/2018, comma, a working capital loan agreement was executed between petitioner and respondent number 3 and comma in their capacity as partners of MSSB Enterprise. Full stop. Additionally, comma, respondent number P4 extended their personal guarantees for securing the said facility. Full stop. To secure the said facility, comma, respondent 3 and 4 created an equitable mortgage by depositing the title deeds of immovable property, comma, land measuring 0.06 acres situated at Mauza, Juripara, comma, jail number 113, comma, LR Khaitan number 724/1, comma, LR plot number 1549, comma, and land measuring 0.010 acres, 0.010 acres situated at Mauza, Dinhata, comma, jail number 108, plot number 9159, comma, Khaitan number 3209/1, comma, both under TS Dinhata, comma, ward number 14 of Dinhata municipality, comma, district Kuch Bihar. The said facility was availed and utilized by the borrowers. Comma, however, comma, they eventually defaulted in payment despite repeated reminders from the petitioner. Consequently, comma, the loan account was classified as non-performing asset on 30th/11/2020. Full stop. Thereafter, comma, the petitioner issued a demand notice dated 4/4/2021 under Section 13(2) of Surfacey Act, comma, calling upon respondents to repay an amount of rupees 1,39,55,598.20 within 60 days. The said notice was duly published in English as well as vernacular newspapers. Full stop. Respondent number 3 and 4 submitted their objections dated 10/9/2021 under Section 13 bracket 3A of the Surfacey Act, comma, which were duly replied to by the petitioner by reply dated 23/9/2021. Full stop. The petitioner, comma, having complied with the requirements of Section 13 bracket 4, comma, took symbolic possession of the secured assets on 18/5/2022 and issued appropriate intimation to the borrowers, comma, along with public notice in newspapers. Next, in the meantime, comma, the respondents preferred an appeal under Section 17 of Surfacey Act before Debt Recovery Tribunal. Full stop. However, comma, no interim protection was granted to them. Full stop. Apprehending resistance in taking physical possession comma, the petitioner filed an application under section 14 of Surfacey Act before the district magistrate, Puch Bihar, on 19/7/2022. Full stop. However, comma, the said application was rejected by the district magistrate by impugn order dated 31/1/2023, comma, citing the existence of a stay order by the Honorable Supreme Court, comma, and granting liberty to the petitioner to file a fresh application. The order was communicated to the petitioner on 22/3/2023. Full stop. Aggrieved thereby, the petitioner has approached this court by way of the present writ petition. Full stop. Learned counsel for the petitioner submits that the impugned Miss Srijani Ghosh, learned counsel
Lordship.
petitioner, submits that the impugned order is without jurisdiction and is liable to be set aside. Full stop. She contends that the district magistrate, comma, acting under section 14 of the Surfacey Act, comma, performs a ministerial function of verifying documents, verifying compliance with statutory conditions, and is not empowered to adjudicate on legal issues such as the validity of the NPA classification or the existence of a stay. She further submits that the interim order passed by the Honorable Supreme Court in WPA number 476 of 2020 merged with the final judgment dated 23/3/2021 in Civil Appeal number 955 of 2020, comma, wherein the Supreme Court refused to extend the moratorium beyond 30th of August 2020. Full stop. The petitioner's application under section 14 of Surfacey Act was filed thereafter, comma, on 19/7/2022. Per contra, learned counsel for the respondent number 3 and 4 supports the impugned order and contends that the declaration of the loan account as NPA was itself vitiated, comma, having been made during the pendency of the Honorable Supreme Court's interim stay order. Full stop. As such, comma, the proceeding initiated thereafter are illegal and not maintainable. This court has heard the argument advanced by the counsel for the parties and has perused the documents on record. Full stop. A perusal of the impugned order dated 31/1/2023 reads as follows. Impugned order आप उठा लेना, पेज बता देता हूँ. It is evident that the impugned order is a non-speaking order, comma, bereft of any discussion on facts, comma, legal provisions, comma, or the effect of Honorable Supreme Court's final judgment dated 23/3/2021. Full stop. There is also no reference to the particulars of the alleged stay order or how it continues to operate post disposal of the said writ petition. In the considered opinion of this court, comma, the impugned order dated 31/1/2023 suffers from serious infirmities. The order is entirely non-speaking, cryptic, and passed without any due application of mind. It fails to disclose any cogent reason or reference to any material record justifying the conclusion arrived at by the district magistrate. Full stop. Merely stating that a stay order of the Honorable Supreme Court exists at the time of NPA declaration without specifying the nature, duration, or legal effect of such stay orders renders the order arbitrary. Full stop. It is further noted that the stay has already merged with the final judgment of the Honorable Supreme Court dated 23/3/2021, and thus could not have been relied upon as a valid ground for declining assistance under Section 14 of the Surfacey Act. Full stop. In view of the above discussion, this court is of the considered view that the impugned order is legally unsustainable and is, accordingly set aside. The matter is remanded back to the district magistrate, Cooch Behar, GM section, close, who shall consider the petitioner's application under Section 14 of Surfacey Act afresh, after verifying compliance with the mandatory requirement as prescribed under the statute, and pass a speaking and reasoned order in accordance with law. Such an exercise shall be completed within a period of 4 weeks from the date of receipt
Grateful, Your Lordship.
of this order. Full stop. From the date of the server copy of this order. Full stop. It is clarified that the server copy. It is clarified that the district magistrate shall not be influenced by any observation made in the impugned order dated 31/1/2023 and shall confine himself to the statutory scope of Section 14 of Surfacey Act, which does not include adjudication of disputed or legal interpretation beyond the ministerial satisfaction of compliance with the aforesaid direction. The present writ petition stands allowed.
Grateful, Lordship. Lordship, subject to your Lordship's correction, Lordship, the first line, the case number of the Section 14 application, Lordship, it would be case number 28/2022, Lordship.
28/2022.
And the Honorable Apex Court's order, Lordship, that would be WPC instead of WPA, Lordship. That would be WP in bracket C instead of WPA, Lordship.
WPC, yeah. I'll just.
Grateful, Your Lordship.
That's what.
Just.
Item number 40, my lord, I am for the petitioner. Am I audible, my lord?
Just a minute, Yeah, page 237. 237. Yeah. Order यहाँ पूरा, ये tick to tick. ये ठीक है, A, B, C, ये तीन. Yes. 30.
Item number 40.
Item number 40.
I am for the petitioner, my lord. Am I audible?
Uttar Banga Kshetriya Gramin Bank.
My lord.
Yes.
40.
Item number 40. I am for the petitioner.
What do you want?
My lord, this is with regards to the pygmy depositors. Khudro Sanchaya Prokalpo. My lord, pygmy depositors are merely private individuals who collect the funds from the villagers and submit before the bank. They are neither on our payroll nor they are at all enrolled with the bank, and they are absolutely casual workers. So their main work is to collect the funds, deposit it before the bank, and get a commission out of that. That was the entire job. They were never in the payroll.
Who's appearing for the?
I am for the Collectors Association. Respondent number 3, Millard, we were the claimant before the
Who is the
tribunal.
answering respondent?
I am the answering.
You are the answering. Yes. There's a ID award.
Yes, Millard, pardon, Millard, I could not get it.
There's an industrial dispute award.
Yes, yes.
My
The
lord.
award, they're up against the award. Now, Millard, our
Page number
opposition-
123.
Millard, opposition was served long back, affirmed long back. Millard, I'll just put it on record today. Our opposition.
It was not filed before.
No, Millard, it was not filed before. Millard, it has
There
been
are, have you served them?
Yes, yes, yes.
Yes, I have
given the
received.
reply also.
Affidavit in opposition filed on behalf of respondent number 3 is taken on record. Do you want to file exception to this?
Already
No, my
filed.
lord.
They
No,
have
my
they have
lord.
filed the reply.
We'll hear it.
I have
first.
filed the reply.
They have filed the
Let this
reply.
matter be listed. Due to paucity of time, the matter can't be taken up for hearing.
Sure.
Let this matter be listed before the next.
Millard, kindly text it up tomorrow. Millard, I'll tell Millard the reason, Millard. We have mentioned this several times earlier. Millard, all this, the association people who are the beneficiaries of this, Millard, they are all in their 65, 66, 70 age bracket. Everyone is suffering, Millard. They
We'll
need
see
this award.
We'll see tomorrow, not today. We'll see
tomorrow. Grateful, Millard.
Tomorrow.
But considering the situation, I'm making this request. Otherwise, Millard, I won't have troubled your lordship.
My lord can take it up tomorrow. I am ready with the matter.
It's absolutely squarely covered by the Honorable Supreme Court. Won't
We'll
take
see
much time, Millard.
Yes.
41. Well, I'm praying for a leave to file an exception.
My lord, I have opted. Because my lord, the contract, my lord, is more of a private in nature. My lord,
There is no exception to be filed for this.
Yes, so the report file of leave.
To what report? She's not filing. She has just given a.
Yes, given.
It's not a. It's not a report. It is basically an information that they have cancelled. I'll hear your petition, sir.
It is a report file of which. It's a report.
It's just a resolution that they have cancelled it.
Let me file an exception to this matter.
because my lord.
There is no. What will you file exception to it? Is your contract been cancelled? Are you aware of it?
No,
You're not aware of it? Then we'll decide the issue.
yes, kindly, my lord, cease,
I'll.
kindly cease one thing.
Sir, I'll decide this issue that this petition has become infructuous in view of the fact that they have cancelled your contract.
My lord, kindly cease
Yes.
that whatever was ended to your lordship yesterday. Here purportedly, my lord, meeting was.
This is listed for tomorrow, I believe. We had asked for tomorrow.
Both of us, here, my lord.
Can we take it up, lordship?
We'll finish. All right.
Why,
It's already been decided by lord.
why extend
My
my,
lord, it's a separate cause of action, lordship.
my lord, kindly.
You have a separate cause of action,
My
Mr.
lord, kindly appreciate, my lord.
It's no such react to this regard, lordship.
No, this.
Mr. Bhattacharya,
First time.
Mr. Bhattacharya, once they have cancelled the tender, the contract, then you have a separate cause of action.
But this is,
Exception to this will not work.
this is for the first time they are taking.
That's all right. Now you are aware of it.
And kindly appreciate, whatever.
Whatever, rightly, wrongly, whatever they have done.
And kindly, this meeting of the board
had purportedly taken on 30th of May 2020. In January 2023, when the first writ petition was heard, the specific submission by the municipality before the Honorable Court was that the contract of petitioner number 2 in that writ petition has been cancelled. None of our writ petitioner number 2 is not before your lordship.
Mr. Bhattacharya, tell me one thing. All these submissions, how will this court, suppose what you're saying, let us assume it to be true. What orders do you expect this court to pass? After they have taken a decision, you tell me, what order do you expect this court to pass?
But decision, my lord.
A decision has been taken rightly or wrongly. All these points you can agitate in another round of litigation where you challenge this, that the action which they have taken is absolutely perverse. They could have not taken it. During the pendency of the writ petition, they have done this or whatever it is. But today, when they have taken a decision, what can I do?
What they are saying, they have taken a decision.
They have
not taken a decision because after this decision was purportedly taken, my lord, before the Honorable High Court, they said that only the contract of one of the writ petitioners in that writ petition has been cancelled. In respect of this writ petitioner, only the payment is due.
Today they have cancelled it, Mr. Chatterjee.
This, according to them, it was cancelled in 2022.
Whatever it is, they have cancelled it. That's what they are saying, that they have cancelled it.
No.
Now it is communicated to you. You challenge it.
I leave it to you.
You challenge.
I leave it to you.
Learned counsel for the petitioner seeks to.
No, my lord, kindly not write that. Kindly dismiss it on merit.
All right, then argue, I'll dismiss it.
Well, I have made my arguments. She wasn't pleased to hear that at length.
No, very different sets of facts.
Yes. Because this point, my lord, I'll take that.
The petitioner, the respondent, has filed a report wherein respondent has filed a report. Respondent municipality. No, just take down. Respondent municipality appears and states that the agreement between the respondent and the petitioner has been cancelled on
30th May 2022.
30th May 2022. Full stop. The petitioner states that he has not been communicated of any such order. He has not been communicated with any such order wherein the contract of the petitioner has been cancelled. Full stop. Be that it may, today, since the contract between the petitioner and the respondent has been cancelled, the petitioner is at liberty to challenge the same in accordance with law. Full stop. The petitioner had filed the presented petition seeking enforcement of the contract entered between the petitioner and the respondent municipality
On 4th of
on
May 2018.
4th of May 2018, whereby the petitioner was granted the right of advertisement on two unipole hoardings situated at Kuch Behar Suniti Road near Raymond's Chowpatty and Kuch Behar minibus stand BCDS bus terminus. Full stop. Petitioner had filed the presented petition seeking enforcement of the tender of the contract entered into the contract entered between the petitioner and the respondent in the year 2018. Full stop. though the said contract has already been terminated by the respondent on date, give me the date,
30th of May 2020.
30th of May 2022. In view of the said fact, the present writ petition is infructuous since the petitioner, the right of the petitioner originating from the earlier tender has already been put to an end. The petitioner is at liberty to challenge the subsequent order of termination of his contract in accordance with law. With that, I can do nothing. Even if I want to give you relief, what relief can I? Tell me.
Which I prayed for, man.
How?
Because this is a delicate,
Mr. Bhattacharya, you are saying, and you are an officer of the court first, and then you appear from.
definitely. But if I have said something otherwise, I apologize.
No, I'm not saying that. I'm just saying that maybe your client would be aware of such a development of 2020.
My lord, my specific instruction is they were not aware, and the municipality has not submitted any document showing communication of this.
Honestly, you should have withdrawn this and taken the right to challenge it. But since you are not doing it, and I'm not being harsh in my order at all.
I'm grateful for that part, my lord.
I'm not being harsh.
But for being, my lord, not too harsh and not to, my lord, record anything adverse.
I could have just, your rights would have been closed even in the next round of litigation.
I know, my lord, and for that part, my lord, I will.
All right. Definitely. Dispose. Nothing survives in the present petition, the same has become infructuous.
But after the petition.
Yes.
Well, here, my lord, the genesis of my grievance in this writ petition is that, my lord, an allegation has been, my lord, labeled against me. My lord, I happens to be, my lord, a skilled technical person working in the, my lord, the block development office within the district of Jalpaiguri.
Yes.
Now, my lord, I have been, my lord, discharging my duty as the post I have been entrusted. My lord, all of a sudden, in the year, my lord, 2021, my lord, an allegation has been labeled against me that I have, my lord, misappropriated an amount of rupees 1,10,000 something. Thereafter, my lord, show cause notice has been issued against me. My lord, I replied.
What is this matter? Departmental proceedings?
No, my lord, no departmental proceeding has been initiated. My lord, I replied to that show cause notice. My lord, thereafter, having been satisfied, the authority, my lord, asked me to, my lord, return back the entire alleged amount. And, my lord, a few, my lord, bank details have been provided to me. In compliance of that, my lord, I, my lord, returned the entire amount, alleged amount that has been, my lord, allegedly, my lord, the allegation that has been, my lord, labeled against me. My lord, thereafter, my lord, since from 2021 to till date, my remuneration has been, my lord, withheld. Despite the fact that, my lord, I have been working till, my lord, the filing of this writ petition for last, my lord, 5 years, no remuneration has yet been paid to me. All has been withheld.
Or in this matter, there is a direction to file report on behalf of the respondent number 2. Affidavit in the form of report. My lord, we
There
have
was a
collected.
direction, my lord, long back, my
Well,
lord.
Lordship, in the meantime, one can application filed by the adding respondent, Lordship. So let it be said, then we will come back with the appropriate report because we don't have stay with our.
You, who are you, Mr. Mishra?
That's what I'm saying, Lord. At paragraph 6 at page 5, my name happens to be Ramesh Mandal.
Paragraph 6 at page
5 of the writ petition. My name has been taken
of the writ
up
petition. Wait a minute.
6 times.
Wait. Paragraph 6 at page 5. Your name has been taken. You're so popular.
I'm very popular. My name has been taken 6 times in one paragraph.
You are Ramesh Mandal.
Yes, my lord. My lord,
And there's a
this
lot of-
person whom my lord make me, my lord, the scapegoat, my lord. I have been instigated by this person. I have been asked, my lord.
Because certain insinuating allegations have been made here, and I may be added as a party member so that I can defend myself.
Absolutely not, my lord.
Why?
Otherwise,
this
let them
problem-
file a fresh writ petition.
I need to confront this.
My lord, so far my lord status is
All
concerned,
the
my lord,
application has been
I have
confirmed.
complied, my lord, each and every direction that has been, my lord, given by the authority, my lord.
Either my lord, the name
Even, my lord,
shouldn't have
the
been taken.
entire amount has been returned back.
Oh, it's okay. Either the name shouldn't have been taken. He could have easily
No,
said
my lord, in
over-
the show cause notice as well as other proceedings, his name has been, my lord, added. That is why, my lord, I was constrained to, my lord.
So make him a party.
My lord, I will be jeopardized, my lord, because this person was instigated me, my lord.
So that's what you believe in others.
And my lord, the adverse situation from which I am going through, my lord, I have been completely, my lord, my salary has been completely, my lord, withheld since from 2021.
We'll see that. You file your report. We'll see, Mr. Nish.
And my lord, let there be, my lord, interim direction so that my lord, area of salary could be, my lord, paid, my lord.
Let them file their report. Who appears for respondent number 2?
My lord, last direction was on, my lord, 1st of April 2025. My lord, if in this way the matter will go on, my lord, I will be, my lord, the oath sufferer, my lord.
No, the CAN application is my application.
Who's appearing for respondent number 2?
Lordship, state lordship, we are
You're appearing?
All the
Why are you taking so long? with
No,
this?
lordship, our report has come from the concerned authority. We are waiting for the CAN application, lordship. That is the main issue.
Lord, how
Otherwise,
much, my lord?
For what? CAN application?
Because
Yes, it's
because by
pending.
this time we received this CAN application, so.
That's
No,
all
my
right.
friend,
Why are you're not
completely
bothered by the
Lordship,
CAN?
we are seeking for 1 week extension of the filing the report. Lordship, by this time we will file the report because our report is ready.
What is the mandatory direction, my lord?
Learned counsel for the respondent number 2 seeks and is granted one
And my lord,
1 week time to file her report by way of an affidavit.
1 week.
Full stop. Let this matter be listed before the next available.
my lord, let there be a mandatory direction, my lord.
Filing
Within
is
1 week I will file.
Mandatory, my lord.
Our mandate.
Miss Bose will do it. No, you should know your colleagues by now. If she's
Last
making a
direction was
statement,
on, my lord, for April, my lord. We are on June, my lord.
she has made a statement today.
By this time, this matter is not listed.
She will not make a statement like that. You know, we should all know the lawyers who
But
make the right submission. Next. Sir.
এই নাম দিছিস? এটা আমাদের পরিচিত আছে। এই এটা আমার Lordship, I beg separate for the state lordship in this matter. There is a direction filing affidavit in opposition, lordship. I seek 2 days time, lordship. My affidavit is ready.
9th of April, my lord. My lord, 9th of April, the direction was given, my lord.
He's
The
asking
time
for
period has
2
expired.
days, Mr. Raw.
Affidavit is ready.
Learned counsel for the respondent state seeks and is granted 1 week time to file her affidavit in opposition. Affidavit in opposition.
Opposition.
Reply to the same, if any, within 1 week.
Lordship, a week, lordship, yes.
Within 1 week thereafter, list after 3 weeks.
Deeply up.
Grateful, your lordship.
No, pass over. Follow. कौन सा है?
27, my lord.
Who's that?
Yes, my lord. My lord, I am there for the petitioner.
Oh, there's no Miss
My lord,
Sarkar is not here.
Miss Sharkar will be there, my lord, because she was appearing with me only in court number 1 right now.
All right. Can't have it today, sir. It's too late.
My lord, day after tomorrow, if lordship kindly pleases. Not tomorrow, my lord. Tomorrow I have a matter before the Honorable Delhi High Court tomorrow, my lord.
All right, keep it day after tomorrow.
I'm so grateful, my lord. I'm
We'll
so
see
grateful. Grateful, my lord.
দেখেন কারো নিচে আছে সব দিয়ে আমাদের এখনো আগে ওগুলোর মধ্যে দেয় আমি বন্ধু একটু দেখ গাড়িতে দেখো ধীরে এখন কোথায় হ্যালো হ্যালো আছিস বন্ধ তো আসছে পুরো হয়ে গেছে লোকটা খরচা ছিল তাই থাকবে একটু উপরের দিকে নাও আমি তো নিয়ে নিছিলাম হ্যাঁ ফলো করছি দেখেন ডিপার্টমেন্টের না কি জানি তো
আচ্ছা আপনি ছেলে একবার তারপর ওগুলো সিবি আমি তাহলে তোমরা খালি ফাইলটা দিয়ে গেলাম ফাইলটা না যদি না করো এভাবে দিয়ে দাও করে কালকে সমস্যা দেখা হলো বলে আমি ফাইল নিয়ে করে না কালকে দেখা হলো কি আমি এখন আমি সব ফাইল তো আমি স্টাডি করে দেই